Listed here, is it? The Standing Council PWD has tried to raise the issue of disputed questions of fact. The said issue, though, may be available to be taken in a case of in a general case of contractual bills. In the instant case, the said issue is not available to the department in view of the categorical statement of facts made in the affidavit of opposition filed in the earlier proceedings, as well as the observation of this court in the judgment and order so and so, including the division bench, while dismissing the appeal WA 97 of 2013. Therefore, it appears that the denial of the department to release the balance amount of rupees so and so is without any basis, which is a part of the legal entitlement of the petitioner, even after reduction of the estimated amount from 121 to 105. This court is also of the view that since an exercise of due diligence has already been done, reducing the estimate amount, it would not be open for the department to further reduce the amount to the prejudice of the petitioner, that too on the basis of certain calculations in the measurement books, which expressly are unacceptable, both on account of the date of measurement as well as the works for which the measurement has been shown to be done. In view of the aforesaid facts and circumstances, the instead petition stands allowed by directing the PWD to release the balance amount of so and so within a period of 45 days from today, failing which the amount would carry interest at the rate of 12% per annum. Records returned back.
My lord, urgent repetition that may be listed tomorrow. I have filed yesterday. It is relating to eviction. Is excessive jurisdiction of the deputy commissioner, my additional deputy commissioner to evict me from
eviction from what? Forest land?
No, my lord. This is not private, my lord.
Private land.
Yes,
my lord, I have clear prayer, my lord. The illustrated query settlement. The matter is going to be influxed by Friday, my lord. Matter is going to be influxed by Friday, my lord.
Have you filed?
Yes, madam. We have filed yesterday, madam.
Okay.
Tomorrow, madam.
May I please, lordship? I beg to mention, I don't know 32 and 33, lordship. Lordship has already heard the matter substantially, and lordship had ordered it at 21.3. Lordship has directed to release the matter for admission hearing, but today matter is listed as the last item for order, lordship.
That
Yes, lordship.
IAM matter.
Yes, lordship. Can it be at 2 p.m. lord?
There are two parted matters.
We have taken consent.
One parted is yesterday, one was earlier.
The interim order is operating, lordship. Therefore,
but we cannot. Parted has to be given priority. Two parted.
at 2.
We cannot say. I will try. Okay. Maybe after the parted matters are over.
Yes, sir. Lordship, another prayer for item note 12, lordship.
12.
Yes, sir. We are for respondent Oil India Limited, lordship. We have taken consent for the petitioner as well as the government councillor. So it may come after vacation.
Nikunja Bhattakur.
Yes, yes. We have taken consent for the Planet Senior Council.
When do you want?
Vacation.
There's some problem with call me update.
Okay, when do you want?
I know on
A prayer for adjournment has been made by
10th of
Sri K.
April,
Kurita, Learned Standing Council, Oil India Limited, as agreed upon by the parties. List on
11th of April, my lord.
11th April.
Or maybe 12th of April.
11th April is a Sunday, I think.
11th April will be Tuesday, my lord.
Then 13, lordship.
Oh, okay, sorry. 11th April is a Tuesday. We'll have it on 12th.
My lord.
Yes.
So those may not be feasible. Because on the eve of, even on the eve of the vacations may not be feasible.
On
Have it on 19th?
my lord.
On 19th.
Obliged, lord.
Item number
12, lord.
19.
12.
Yes, 19.4.
May I please, lord? My lord, I may be allowed to move an unlisted, listed motion to follow, my lord. There's some-
Filed already.
There's some file, my lord. WPC 3623.
Urgency is there.
Urgency is there, my lord, because
Oh.
31st is coming, my lord, and my excise license has not been, my lord.
Renewed.
provided,
Renewed.
Renewed, my.
Okay.
Fine. Quick note.
Lordship, I pray for listing of a matter tomorrow, Lordship,
For
for
motion.
motion, Lordship. We have filed it today, Lordship. There is an urgency, Lordship. There is a recovery proceeding of a forest royalty, Lordship, before 31st. The arbitration proceeding is already pending, Lordship. During this pendency, they have issued a letter.
Just a minute. Hey. Bench, খালি তো পুরো দিছে তো ওরে ইয়াতে কেউ মেনশন করে দিয়ে কেউ কোনা I think mentioning have to be done before court number 4. Court number 4 has been assigned the bench 4. That's the first senior court. We are sorry, we will not be able to, not be proper if we allow mentioning.
Lordship, I'll try there.
Kali matter like the asset, one the council block.
It please your lordship, this is a contempt case.
No. Listed matter is not an issue. For unlisted, who had mentioned?
Lordship, but the order was passed by this court lordship in contempt matter lordship for listing. Actually,
Is it necessary that the matter has to be has to come before the same court?
yes, lordship, better know.
There is no such rules. If there is a senior court, you have to mention their bench 4 matter for listing purpose.
In fact, on yesterday also your lordship indicated.
Indicated. No, today we just keep it off our mind.
But in fact, item number 31, my lord, is for withdrawal, my lord. We had made a mention, my lord. We have come for withdrawal column.
31.
Yes, ma'am.
You want to withdraw?
Yes, ma'am.
Which is this matter? Same.
Yes, yes, ma'am.
Saigopa.
Yes, ma'am.
Pos.
My lord. Same parity, my lord. Effect of other.
Not a very healthy sign.
No, my lord, absolutely not, my lord. All wickets down, my lord.
The R to be. And IA for withdrawal.
Yes,
R to be rendered counsel for the applicant petitioner submits that the IA has been filed for withdrawal of the writ petition. Full stop. The writ petition, it appears that the writ petition was filed on the subject of a contract matter, and the same was heard on a few number of occasions. Full stop. No discernible reasons appear to, no discernible and acceptable reasons appear for such withdrawal. Full stop. In view of the above, while withdrawal is allowed, the same is subject to payment of cost of rupees 50,000 in favor of the Benevolent Fund, Guwahati High Court Bar Association.
Lordship, one IA is there in this matter, Lordship.
IA for
IA for implement, Lordship.
that has been allowed, my lord.
Yes, Lordship, Lordship, and dispose of that IA.
IA, what was the IA? That was allowed.
That was allowed and they have been implemented. So in the I also we have made a
We can record your name.
Yes, Lord.
Madhur, Tripuri Nayak appears for
4 and 5.
4 and 5.
that's one of 4 and 5. And the
The one is industry, my lord. Mr. Kolita, and 2 and 3 are AIDC. Lord Mr. Goswami.
Jay Goswami appears, Lordship.
is he there?
I'm on behalf of J.
What is your name?
Burman.
Sri J. Burman has appeared on behalf of Sri J. K. Goswami, Standing Counsel AIDC. Whereas Sri Ann Kolita has appeared on behalf of Sri A. Kolita, Standing Counsel, Industries and Commerce Department.
Right, Lord.
With regard to item number, may I pray for taking after the list
13.
30 supply orders. Lord. There is an IA lordship, have an urgent lordship.
Madam, there are two partner matters. Prior to that, we will not be able to take up any matter. IA for what?
IA for restoration of the stay order passed by this.
What had happened?
Lordship, the stay order was vacated. Now the petitioners, they are sought to be evicted from their homes.
The order was vacated after hearing you.
Lordship. A submission made by the respondent. Matter relates to acquisition of land.
Now, if you are aggrieved by such an order, You have to go to the division bench. Can we again, it will amount, won't it amount to
So
review?
we are not challenging the acquisition procedure. Lordship.
No, no,
We
you are asking for restoration of the stay order,
Lordship.
which has already been vacated after hearing you.
Stay order was passed by his honorable Lordship. This, your
Understood.
Lordship.
We have vacated the stay order after hearing you, isn't it?
On the submission of the respondent counsel.
That is
Lordship,
it.
but
Now
award has
it,
been-
now it will amount to a review. I is for review or what?
For the restoration of the stay order, Lordship, for renewal of the stay order.
We have doubts, but not immediately. After the patterns are over, that we can assure. There are two patterns. One is almost over, but one will need some time.
Lordship, my senior has some difficulties after in the second half, Lordship. So kindly matter may be fixed on Tuesday, Lordship. This matter if.
Today,
motion.
today is Tuesday.
Fourth,
Next Tuesday will be late, I think. We can have it day after tomorrow,
Lordship.
day after
Thursday,
tomorrow,
Lordship.
Thursday.
If it doesn't reach to my Lordship.
No, Lordship. As second half, my senior won't be available.
First half, it is not possible. As agreed to by the parties, this case on
38th, Lordship. Please.
Thursday, date you want?
Obliged.
That is Lordship.
Yes.
Lordship, counsel for the petitioner, Mr. A.R. Bhuya is severely ill. Lordship,
Is not well.
no, Lordship.
Okay. you have
My
to-
lord, only thing, my lord, extension of the stay order, the protection granted to him would accord finality to the proceedings. If I may most humbly draw your lordship's attention to page 58 of your lordship's brief.
Lordship can take up the matter on Friday. He is covering Lordship.
Not to
That's
take any coercive action, my lord. That's the main prayer, my lord. That accords finality.
Lordship, the interim.
Lordship,
Interim may be continued till next year.
my lord, I object to that. I have instructions, my lord. From
The
the,
council is not well.
indeed, my lord.
We'll have it on Friday,
Okay, Lordship.
day after tomorrow, or Friday, okay?
Friday or
Or Friday, if it's not available for him, then you have to engage somebody else. We are granting you an opportunity. Will not be that unreasonable.
Okay.
Because when the objection has come, you make some arrangements, okay? A
Inter-
prayer for,
interim may be continued.
a prayer for adjournment has been made on the ground that the council Sri A.R. Bhuya for the petitioner is unwell. Full stop. MS S. Sharma, Current State Council, however, submits that though on principles, he would not object to such a prayer for adjournment, comma. There is objection so far as extending the interim order is concerned. Full stop. Para. After hearing the parties, comma, the registry is directed to release this case for motion on Friday. Friday, and the interim order stands extended till the next date, full stop. It is however made clear that this court would be reluctant to grant further adjournments.
I look at. Yeah, please, Lordship.
Here is my lord, I've filed a complaint, my lord. The brief fact is that my lord petitioner is owner of 3 cutters of land. And my lord, on the basis of some fraudulent document, private respondent, my lord, started construction, building permission has been granted. So I object to that, my lord, and I file a complaint, lordship may see at page 33, annexure 4, my lord. This complaint till now has not been disposed of, my lord. That is one of my grievance, my lord.
Complaint before whom?
Complaint before, my lord, GMD, lordship may see at page 33, my lord.
You say it's your plot of land.
Yes.
They have fraudulently managed some papers and
Some
started
papers
construction.
and this have got. the-
GMDA.
Lordship.
Lordship, in fact, Lordship, the other party has also filed an application before the circle officer, Lordship, and another proceeding is going on as regard the same plot of land in which he is a party.
No, at least what action have you taken on his complaint?
Lordship,
Have you issued notice or anything?
that instruction I have to
You
obtain,
get the instructions, you have to take their response.
Lordship.
We don't know, he may be correct, he may not be correct.
Yes, correct.
But since He's approached the authority, at least notice has to be issued. Take
Lord-
their response, then you act.
And there is a miscase going on, my lord, with regard to the Jamabandi, my lord. And there also, my lord,
Arts free, J. Roy, Learned Senior Counsel. Who is aggrieved by the inaction of the GMDA to act on a complaint lodged by him on 5/4/2022, correct?
my lord.
It is the case of the petitioner that he is the owner and recorded partner of a plot of land measuring 3 katha, covered by DAG number 3815, KP Patta number 1659, village number 1, Japuri Gog, Musa Beltola, in the district of Kamrup M. However, the respondent 6 has started construction on the basis of a permission obtained on fraud documents. Sarah, issue notice of motion. Returnable by 4 weeks. Housing and Urban. The CKS Burwa State Council accepts notice on behalf of respondent number 1, 3, 4, and 5. P. Nayak,
I'm for
Standing Council, GMDA,
Lord.
for respondent number 2,
Yes, sir.
3, D. Deca, Standing Council, Information Commission for respondent number 6. That extra copies be served upon the learned counsel for the respondents during the course of the day. That steps be taken for service of notice upon the respondent number 7. I raise that post PTD. Steps by tomorrow. At this stage, Sri Nayak submits that as per instructions, the respondent number 6, respondent number 7 has also instituted a proceeding
part of the
before the circle officer, on the next date, the learned counsel shall obtain details of such complaint.
There's one small submission, my lord. Lordship will see page 77.
Hmm.
An inquiry was conducted, my lord. That report also as of today not been completed, my lord. Page 77, my lord.
Sri Nayak could also seek instructions on the outcome of the inquiry which was conducted on the
Right.
issue.
That instruction will come from the deputy governor.
Okay, don't say that. The state council shall also.
Right. Apply.
Lordship, before my friend starts, I would like to give 2 citations, Lordship.
Yes, we are yet to complete your arguments. I think.
No, but Lordship, Mr. Borpuzari was submitting yesterday. Before he starts, Lordship, just 2 citation, Lordship.
One moment.
It is Silpi or another. Silpi construction. Ekmate.
Yes,
Lordship, since it's a distribution of textbooks, Lordship, which involves public interest, Lordship, 2020, 16 SCC 489,
2016,
20, 16,
2020.
20, volume 16, SCC 489.
Oh, this is Silpi, I think.
Yes, Lordship. Para 19 and 20. 489.
Silpi Constructions,
Yes, my lord. And then
19 and 20, isn't it?
yes, Lordship. And Lordship, 2022, volume 5 SCC 362.
Read.
362, page number. Agmatel India Private Limited, okay? Para 24, 25, and 26.
Agmatel. 24,
25 and 26.
Shilpi, for what purpose you are,
Public interest, Lordship, and Agmatel is with regard to the conditions, Lordship. Lordship.
this one? Okay. SSA. You're for SSA?
Yes.
Yes, please continue, Mr. Bopajari.
Yeah, please, your lordship. My lord is taking up WPC 1877, my lord.
Yes, Simon.
Yes, yes, that is the lead case in the series, my lord. My lord, may be pleased to come to page 4 of the repetition. Page 4 of the repetition, my lord, that is the cause title.
I don't know. I do not like. On it. Page 4.
Page 4 of the repetition, that is the cause title which depicts, my lord, the array of parties, the respondents.
One more. You're for R5.
My lord, R5.
Page?
My lord, page 4.
Yes.
My lord, the first respondent is the state of Assam, second is Assam Sarva Shiksha Abhijan, third is mission director, fourth is, my lord, the state level purchase committee, which is, my lord, passed the impugned decision, my lord, which is put to challenge.
Then 5 and 6 are the, my lord, private respondent. Here, my lord, my submission is that, my lord, there is no whisper of mala fide as such in the writ petition, by which, my lord, the person in particular against whom a mala fide is alleged, my lord, he has to be implemented in person by name. That is not discernible from the cause title, number one.
No, you said that there is no allegation of mala fide.
There is no allegation of.
So there is nobody has been made party. What is the argument?
No, my lord, since there is no allegation of mala fide, my lord, then, my lord, it necessarily, my lord, it is a necessary corollary, my lord, that if a mala fide is alleged, the person is, my lord, joined in name. So therefore, my submission is that, my lord, a person is not joined in name as such, and there is no whisper of any mala fide, my lord, in the process of, my lord, tender, my lord, awarding the contract.
No,
The
my
writ
lord.
petition is absolutely silent. There is no statement whatsoever, my lord, in the writ petition, my lord, that the tendering committee, the employer, my lord, had acted mala fide on extraneous consideration with particulars, my lord, specific particulars, as required under Order 6, Rule 4 of the CPC. Those things are silent, absolutely silent. Now, if my lord comes to my lord, page 63 of the writ petition, that is a part of the bid documents, my lord.
Page
Page 63. 63, clause 11.2, my lord, which was heavily harped upon, my lord, yesterday by the petitioner side, my lord.
63.
Page 63, down below, my lord, will find 11.2.
Yes.
I'm reading it, my lord, quickly. The documentary evidence of the bidder's qualification to perform the contract, if its bid is accepted, established to the purchaser's satisfaction, you will have to establish to the purchaser's satisfaction, A, that the bidder offering to supply goods has the minimum capacity of supplying similar quantity or more with a specified time limit in the NIT, a certificate duly authenticated by the competent authority, as for example, a gazetted officer of the industry for certifying the documentary evidence, etc., of the area where the bidder is located, showing the production and supply capacity for the last 3 financial years, turnover for so and so. Then, my lord, lordship will kindly come to the next page, my lord. B, my lord, that the bidder has minimum average annual turnover of minimum 1.37 crores during the last financial year's turnover so and so. Then C. C assumes utmost significance here. C. That the bidder has the financial, technical, and production capability to perform the contract and meets the criteria outlined in the qualification requirements specified in section 6A. Now, section 6A of the bid documents, my lord, pertains to, my lord, criteria, that is, my lord, the qualifying criteria of the bidders. Qualification criteria.
Page,
Yes, now here, my lord,
page 82.
82. At this stage, my submission will be, my lord, that the financial health or the financial capacity of the bidder is a sine qua non, my lord, to be entitled for being awarded with a contract. Now, 82 lordship will kindly come, my lord, clause 3, my lord, subclause Roman 6. Clause 3, subclause Roman 6. Lord, it is stated in no uncertain terms, my lord, it is bank solvency certificate. Lordship has marked it, bank solvency certificate. Down below at clause, subclause 9, my lord, Roman 9. 9. Bidders must furnish certificate of completion.
Not this 9, that's 11.
Yes.
That's not 9, 11.
11, I'm sorry, man, 11. Bidders must furnish certificate of completion of delivery within continuous delivery of 60 days approximately so and so government offices to whom delivery was made. Now, these are the condition precedents.
Yes.
Page 82, my lord, pertains to, my lord, qualification criteria. These are all, my lord, parameters which had been laid down, my lord, in order to enable a person, my lord, who participates, my lord, he would have to become entitled. Lordship will now kindly come to page 88. I'm traveling, my lord, with all these pages.
88.
88, page 88. Page 88, down below, my lord, will find. Well, this is a pro forma. This is a performance statement which has to be given in this particular format. Down below, Lordship will find the above statement must be supported. The word is must be supported by order copy, payments, bills, received vouchers, self-attested photocopy of earlier supplies to purchaser of government department, government undertaking, semi-government, PSU bodies in support of their earlier performance as mentioned in 11.2. Now, they have been rejected on two grounds primarily, my lord, that they do not, my lord, satisfy the so far as, my lord, delivery of goods are concerned, my lord, for the last 3 years. And number two, my lord, they have not submitted the bank solvency certificate. For that, Lordship will kindly come to page 101 for a moment. My lord, it was shown to my lord yesterday. I'm repeating it once again, my lord, with my lord permission.
101.
101. Page 101.
Their consideration.
Yes, their consideration at, my lord, clause number 3. This is JC Stationery Private Limited, Andhra Pradesh. The SLPC has examined the documents and the evaluation statement. After scrutiny and verification of the evaluation statement, evaluated by the evaluation committee, the state level purchase committee observed that the bidder has uploaded the information on past supply from government department for 2 years and 1 year from private, submitted certificate of completion of delivery from private organization instead of government, semi-government offices. Now it is clear. This is important, my lord. Bank solvency certificates submitted in favor of state project directors, Samagro Shiksha, Vijayawada, Andhra Pradesh. Now, my lord, Lordship will kindly come to the last page of the writ petition, that is the solvency certificate. Kindly see the language, my lord. Well, this is issued by Andhra Pradesh Mercantile Mutually Aided. At the top, my lord, at page 106, Lordship will find.
Not the last page. 106 is the second last page. There's one more page, 107.
My lord, in my copy, my lord, it is 106.
No, 106 is not the last page. You said the last page.
My lord,
There's one more page, 107.
my lord, but I am relying.
You don't
on-
have capacity certificate?
Yes, my lord, I am relying on page 106.
No, we have, no, you had said the last page.
Last page, because in my writ petition, my lord, I.
You don't have 107.
107. It is the capacity certificate, it is there, my lord. But however.
Okay,
my lord,
doesn't matter,
yes,
106.
Yes, I am relying on 106, my lord.
Solvency certificate.
Yes. Solvency certificate, my lordship will kindly see, my lord, who had issued that solvency certificate. My lord, at the top, my lord, lordship will find it is Andhra Pradesh Mercantile Mutually Aided Cooperative Thrift and Credit Society Limited. In my respectful submission, my lord, for all purposes and intent, this institution cannot be constituted to be a nationalized bank. Or a bank for that purpose. Solvency certificate. This is to state that to the best of our knowledge and information, so and so, JC Stationery Limited, office so and so is our customer and be treated as good up to the sum of rupees 40 crores only. It is clarified that this information is furnished without any risk and responsibility on our part in respect whatsoever, more particularly either as guarantor or otherwise. This certificate is issued at the specific request of our customer, Mr. JC Stationery Private Limited, to submit the state project director, Samagro Shiksha, Vijayawada, Krishna district, Andhra Pradesh for tender purpose. Now, my lord, two things are discernible from this document. Number one, my lord, it doesn't, my lord, spell out in clear terms, my lord, that this is a bank. Number two, my lord, this, even if it is assumed that this is a bank, Then also, my lord, this solvency certificate has been issued which refers to a particular project, my lord, related to Andhra Pradesh, not with related to this one. Whereas at page 82, the qualification criteria of the bid documents, it is absolutely clear. There has to be a bank solvency certificate. And bank solvency certificate for the purpose of the present tender. Well, I'll be relying on the decisions. Here, my lord, lordship will kindly mark the existence, my lord, of the clauses in the tender documents are not in dispute. It is only the interpretation that is sought to be given by the petitioner, my lord, that he has raised in dispute. It is not that this condition should not be there, this condition should be there. It is not that. They say, my lord, they admit, they accept the tender condition as it is, but by giving a defined interpretation. Now, whether, my lord, an employee can give a, my lord, interpretation of his choice, my lord, against which is contradictory, my lord, to the interpretation of the employer. Lordship, I am relying on Agmatel India Private Limited, which is what my learned colleague has given it. One another decision, my lord, does it NG Projects Private Limited versus Binod Kumar Jain and others. This is, my lord, 2022 6 SCC 127. My lord, I am relying on paragraphs 12 and 13.
22.
Into 2022 6 SCC 127. NG Projects versus Binod Kumar Jain and others. Lordship has got it, my lord. But I am relying on paragraph 12. Lordship may kindly see
12.
paragraph 12. In paragraph 12, my lord, an earlier decision of the Honorable Apex Court has been relied upon. My lord, that was pronounced in FCONS. FCONS Infrastructure Limited.
Paragraph 12. What?
Paragraph 12. 12 and paragraph 13, my lord.
Of course, even Caratel has said, Caratel, there's a judgment of Caratel. Specifically, even Shilpi has said, interpretation of the owner,
Interpretation of the owner.
of the author of the
author,
document.
Yes, my lord, I am reading it, paragraph 12, my lord. In FCONS, so this court held that the owner or the employer of a project having authored the tender documents is the best person to understand and appreciate its requirements and interpret its documents. It was held in so and so. In other words, a mere disagreement with the decision-making process or the decision of the administrative authority is no reason for a constitutional court to interfere. The threshold of Malafite's intention to favor someone or arbitrariness, irrationality, or perversity must be met before the constitutional court interferes with the decision-making process or the decision. We may add that the owner or the employer of a project having authored the tender documents is the best person to understand and appreciate its requirements and interpret its documents. The constitutional court must defer to its understanding and appreciation of the tender documents unless there is malafide or perversity in the understanding or appreciation or in the application of the terms of the tender conditions. It is possible that the owner or employer of a project may give an interpretation to the tender documents that is not acceptable to the constitutional courts, but that by itself is not a reason for interfering with the interpretation given. Paragraph 13, my lord. This court sounded a word of caution in another judgment reported in Silky so and so, wherein it was held that the courts must realize their limitations and the havoc which needless interference in commercial matters could cause. In contracts involving technical issues, the court should have even more reluctant because most of us in judges' robes do not have the necessary expertise to adjudicate upon technical issues beyond our domain. As laid down in the judgment cited above, the court should not use a magnifying glass while scanning the tenders and make every small mistake appear like a big blunder. In fact, the court must give fair play in the joints to the government and public sector undertakings in matters of contract. The court must also not interfere where such interference could cause unnecessary loss to the public, etc. Here is a case, my lord, where pursuant to a award of contract, 100% supplies has been made, my lord, by the private respondents. And there is no complaint whatsoever from any corner, my lord. Now, there is no complaint whatsoever. But
My lord, he forgot that he's appearing for private response.
No, my lord, my
Please
thought
file
was-
this one then.
yes.
No, just now he made a submission.
Hmm.
And government has given the work to private response.
There is no complaint whatsoever, my lord, from any corner regarding the supply made by the private respondent. Number one. And number two, my lord, the writ petitioner has not brought on record any material whatsoever to show or to, my lord, establish in a remote connection that there is malafide, my lord, on the part of the tendering authorities. Vis-a-vis, my lord, the contract awarded to the private respondent. Number three, my lord, no materials to show in the writ petition, my lord, that they have been treated as, my lord, blue-white boys.
You said 100% work completed.
100% was completed and there is no complaint from any corner, my lord.
Then what else?
One more decision, my lord.
What was the other submission
Yes, my lord, there is,
regarding blue-eyed boy?
yes, there is no pleading, my lord, in the writ petition, my lord, that the private respondents are treated as blue-eyed boys, my lord, by the,
You are not blue-eyed,
no.
brown-eyed.
There has to be, if some alleges malafide, one has to meet the requirements of.
But you are in the same boat. The others, brown-eyed or blue-eyed,
Well, and
brown or blue.
My respectful submission would be, my lord, the writ petitions, my lord, falls short to meet the
No, you have
requirements.
said there is no allegation of malafide.
Malafide,
That we have accepted.
yes, no. Well, then one another decision I am relying, my lord, this is Galaxy Transport Agencies versus New JK Roadways. Well, this
This
is,
expression, fair play in the joints, what is the meaning?
my lord, my lord, if any reasonable doubt exists in the mind of the employer, my lord, so as to, my lord, form.
Where is it originated from? Fair play in the joints?
My lord,
Starling Computers, my.
yes.
90.
Prior to that, there is another case of Doordarshan, Ashish Chaudhary.
Yes.
But somehow, while
My lord,
discussing
before-
that, and
lord,
in
we
paragraph
often-
88 of Tata
We
Cellular,
often talk of Tata Cellular.
free has been left out. It should have been
Except, my
free.
lord, The excise commissioner vices Isaac Peter and Starling Computers according to Miadi leading judgments.
No, the expression, I think,
Yes.
while
Free
in-
play in the joints.
in paragraph 88 of Tata Cellular,
Yes, free play in the joints.
the expression has been made fair play.
No, it should be free.
It should have been in free play. But all others
Free
are
play,
using
my lord, there should be some.
leeway, some
leeway
elbow
is required
elbow
for
space, some
administrative authority,
leverage, you take decision.
depending
Expression.
upon the administrative exigency.
I think that there's the Ashish Chaudhary versus
Free play.
Doordarshan, 80 something. And Sterling Computers also.
Yes, I think Starling Computers of 92, my lord.
Ashish Chaudhary किती आहे? Just type out Ashish Chaudhary versus Doordarshan. You have Tata Cellular.
Tata Cellular, I have not got, my lord.
Anyone having Tata Cellular? আমার আছে না এটা? এই, দেখা।
94, 6.
Tata Cellular এখন আছে না? Tata Cellular ভিতৰত Tata Cellular citation.
94, 6, 65.
কিতাপটো নাই আমাৰ ফটো কপি কৰা আছে very much. Yes, what else?
One more decision, my lord, it will be my last decision, whether this is Galaxy Transport Agencies.
Yes, Galaxy.
Yes, my lord, this is reported in 2020 SCC online, SC 1035.
Galaxy is by you.
Yes, my lord.
Interestingly, it has been typed, it has been photocopied. And the reverse is Rana Construction. Somehow you are there.
It's good, my lord. Why
It's good
this-
you are using the page. It's
No, no,
good.
actually, it's time, my lord. Even for the rafting, we also do in chamber.
Tata Cellular is developer. Galaxy,
Galaxy, my lord.
2000 and, is it reported?
My lord, it is reported in
2022, 5 SCC.
Yes, I am relying on my lord the
No, no,
SCC.
no. What is the SCC? Online, it's online. 2020,
2020 SCC online, SC 1035.
1035.
Yes.
Galaxy Transport.
Galaxy Transport, my lord.
Yes.
This is with regard to my lord pleading malafide. I'm relying on paragraph 18.
Why are you again malafide? They are not pleading malafide. They're only saying malice in law.
So, my lord, if the statements, my lord, how does it affect, my lord?
No, they are
Affect the
not,
rights.
that's not the case. You need not embark upon. Now you're opening a new thing, giving avenue for them. Now you make a submission. What they have not pleaded, why do you have to defend?
This is, my lord, I ought to rely, my lord.
No, if there would have been a
It's not a case of malafide.
malafide,
Yes.
you have been made parties, somebody have been made parties, then you come. Now you have, when you so the opening submission, you
I'm
said
not relying that, yes.
may not be an appropriate case.
Otherwise, my lord, the narrow compasses, my lord, they are thought to give, they are, my lord, seeking to give an interpretation of their choice against, my lord, the decision of the, my lord, tendering committee. This is the existence of the clauses, my lord, the terms and conditions are not in dispute. They are only giving interpretation of it. Now, how far, to what extent that interpretation is permissible? This is the issue. my lord.
And you have not addressed upon a reasonable interpretation. You can address upon that.
Otherwise, my lord, I have drawn my lord's attention, my lord, to the pages, my lord, to the documents, my lord, which they have, my lord, furnished.
Whether it will appeal to a reasonable mind,
No,
that you can.
yes. That, my lord, in my respectful submission, I have already submitted, my lord. They have not, my lord, complied with the requirements of the, my lord, tendering authorities. And as such, my lord, their bid has been rejected. And prima facie, my lord, it is written on the face of the record, my lord, that page 106, that is the solvency certificate. From no corner, my lord, it can be, it is discernible, my lord, that this institution is a bank for the purpose of this, my lord, tender.
And what is the requirement bank?
Bank.
It is something. Good goal, good. Overview of bank and BRT Act. Overview of use. That's a bit. No.
That's a cooperative bank, my lord, recognized by the Reserve Bank of India.
It's-
Hey, 88.
DRT Act defines bank.
Yes,
to-
including a cooperative bank.
and including a multi-state cooperative bank.
Yes,
Now, whether it's a cooperative bank.
it's a cooperative bank, my lord. If necessary, will actually, my lord, none of these points are pleaded in the affidavit, so we cannot be taken by
But
surprise.
DRT also makes a distinction between
Yes,
bank and a financial institution.
yes,
Financial institution means something else.
yes.
But you may be correct in pleading, contending that the rejection is not on the account of bank. Rejection is on account of that it is meant for some other organization.
Yes. Now, my lord, please come to 101. Let us test the argument. I'll just take 10
We
minutes.
can, it's over, your thing is over? Anything else, nothing?
But only my lord that my
Sorry.
Lion senior counterpart is making a submission, my lord, that what I have submitted is not a part of the pleading. And we have already filed IAs, my lord, interlocutory application. And that in all the cases for releasing the payment. And my lord, in those interlocutory applications, we have made, my lord, specific statements, my lord, to this effect. My lord, that how the decision making authority, my lord, they have found that they have to be rejected. That they have not complied.
No, your
those-
submission will be is unacceptable on 2 grounds.
my lord.
You can essentially, you cannot say pleadings, statements in the IAs are pleadings. Number one. Number two, you have to have some statement or affidavit in support of something which is on record. This is not on record.
Yes.
The rejection is not that it's not a bank. Rejection is that the certificated 106 is meant for some other purpose, some
Yes.
other party.
Yes. Some other purpose, and my lord, it is my.
And more so when you are a competitive bidder,
Yes.
you cannot influence
Yes, ma'am, definitely.
decision will be independent
This
taken
is
by
a-
Mr. Chaudhary.
My lord, but what I am submitting, my lord, on the basis of the, my lord, materials available on record. To persuade my lord, to see as to whether, my lord, that's
So
solvency.
this point could have been taken by them, but they have not taken.
Yes,
That whether Andhra Pradesh Mercantile Mutually Solutions Society is a bank or not. They have not even raised any whisper that it's not a bank. But this may be a point for consideration.
well, since we have not filed affidavit, my lord, so, on an earlier occasion, my lord, I made. a
Yes,
submission.
Mr. Chaudhary.
Yes.
My lord, public order publicly made has to be construed in the context in which it is made. So para 3 at page 101. SLPC has examined the documents and evaluation statement. After scrutiny and verification of the evaluation statement, evaluated by the evaluation committee, the state level purchase committee observed that the bidder has submitted, uploaded the information on past supply from government department for 2 years and 1 year from private, submitted certificate of completion of delivery from private organization instead of government semi-government office. This is one. Bank solvency certificate in favor of state project Samagra Shiksha Vijayara and Andhra Pradesh. And of the literal meaning which can be given to this finding of the state level purchase committee was, my lord, that while demonstrating our experience, my lord, we relied upon for the 3 out of the 3 years. For 2 years, we have shown that we have supplied 2 government agencies. And for 1 year, that is 1920, though it is not mentioned, but that is the inevitable conclusion that we gave certificate of supplying to a private organization, that is ITC. Now, I have already shown at page 50 of the writ petition that we have given to the government department, which was for 7.22 crore against the requirement of, my lord, 1.37. In addition, my lord, at page 44, we have given another order of 72 lakhs and page 57 to that, my lord, ITC. So, my lord, they cannot say, so therefore, the ground on which my technical, one of the ground on which my technical bid was rejected was, I did not submit experience certificate of supplying to government or semi-government for 3 years, which is not a correct evaluation of facts. My lord, it is essentially a case of wrong evaluation of facts. Now, my lord, as your lordship has rightly pointed out, it is not our case. We are not alleging malafide. All that we are saying is a case of malice in law. Now, my lord, regarding the second point, bank solvency certificate submitted in favor of project director Samagrahika Bidara. My lord, a particular bank has given a certificate to me that I am worth up to 40 crore in the same financial year, though it was in respect of another organization. Would it take away my financial status, my lord? If the stand taken would have been, all right, your liability qua that the Bizoera unit may have been more. Therefore, after meeting that liability, whether anything would survive or covering the risk in this case, if that would have been a ground, then my lord, the employer's view would have been correct. Here is a case, my lord, they're trying to say black or white or black. My lord, let us be very frank about it, my lord. When the Honorable Supreme Court says, my lord, that employer's view should be given due deference, that is in a case where all the exercise is all right. A view has been taken, another view is possible. There the Honorable Supreme Court says that normally these are all technical. My lord, lordship will kindly appreciate, in a case of supply of textbook, any expert opinion is not required. I can appreciate, my lord, in a very highly technical job, in a defense procurements, when, my lord, highly skilled technology is involved. There, my lord, the expert's view is not to be substituted by a constitutional. But as any judgment of the Supreme Court says that when Article 14 is violated, my lord, or if there is illegality, if there is arbitrariness, if there is irrationality, and if the view is also hit by witness principle of reasonableness, then, my lord, the 226 or a constitutional court cannot interfere. Otherwise, my lord, it makes no sense of having 226 jurisdiction. Yes, lordships will give utmost restraint before interfering with a decision, because here is a case where the finance of the state is involved. Quashing of an order will result in so many complications. Eventually, public interest suffers. But, my lord, that does not mean that in every case lordships will, adopt the approach of judicial hands-off. It is not a case where lordships will adopt the approach of judicial hands-off, because it's a case where, my lord, that's why it is in Perium Chemical, Supreme Court said, my lord, that malafide cannot be seen. It has to be inferred from the attending facts and circumstances. When a party having experience of applying textbook worth 30 crore is ignored, we do not know what will appear if the records are called for. This Pragati, what is his experience? Because, my lord, I'll be arguing a case before lordships. The other day, yesterday, that there it was 3 crore, my lord. We have downloaded the financial parameters. One has not indicated an amount, and in one case it is 2 crore. Yet, my lord, they have been shortlisted. That's seed supply. I'll make that submission. So, my lord, we never know if the Pragati's financial documents are verified, what appears, my lord. They may not have 1 rupee also, may not have. Because nowadays, my lord, they are taken for granted. Therefore, my humble submission is, my lord, yes, leeway is required, but that will depend upon the nature of the procurement. That will depend upon the nature of construction. In every case, these principles cannot be applied in, my lord, in REM. Simple experience required is how much textbook you have supplied in the last 3 years. To make that evaluation, my lord, no expert brain is required. Any Tom, Dick and Harry can find out that, my lord. But those principles are not apply here. Because it is said, my lord, a judgment is an authority for what it actually decides. Every observation is not a judgment. Now, for example, my lord, my learned friend has relied upon NG Exports case. What was that case, my lord? In that case, my lord, Specific Relief Act Section 41 was amended, where IAH, something a provision was added, that in case of infrastructure project, court should not grant interim order. It is in that background, my lord, that judgment was passed. Well, the same bench has passed this order, lordship will kindly see. This is Jai Bholenath construction. Kindly see, my lord.
We are aware of this.
The High Court, my lord,
Aware of-
following NG exports, please come to the first para, my lord.
We are aware.
Yes. The sub-para, the technical bid envelope of subject mentioned work was opened on 26/8/21, and LD construction was excluded from process and declared ineligible for non-compliance of document. In this regard, LD construction in personal visit has informed in writing that proper documents are submitted, hence the tender perused again. Therefore, the tender committee again perused the documents and found that LD construction has submitted complete document as they are eligible, they are included in the tender process. Therefore, the technical financial envelopes are being opened again after making some changes in the tender process as per the rules. Hence, the tender committee issued corrigendum in this regard. Then, sir, last para. We have heard the learned counsel for the appellant. We find that High Court has totally misread the judgment of this court. Respondent number 4 was declared eligible in flagrant violation of principles of natural justice and all fairness in the process of determining eligibility of the tenderer. The bid of respondent number 4 was accepted when at the time of opening of the technical bid, said respondent was disqualified. Therefore, in the matter in which the bid has been accepted, shows arbitrary exercise of power. The same bends, my lord. If my learned friend's view is to be accepted, then court must give due deference to their views. It all depends upon the facts of each case. Well, similarly, we do not know whether this, especially this unit called Progoti, whether it has got any capability, my lord. To our information, it has none. So if the records are called for, then it will be evident, my lord, whether they have that experience of 1.37 in each of the last 3 years. My lord, when a writ of certiorari is prayed for, it is the duty of the respondents to, my lord, praise the records before your lordships. If they do not produce, lordships can draw adverse conclusion. My lord, here is a case, it will ensure failure of justice because a bidder was eligible, my lord, he has been thrown out, and my lord, ineligible persons have been inducted. Can be laid down. Then Mr. Chaudhary, my lord, the other day made a submission that, my lord, this society is, whether it is a government department, we do not.
But in your writ petition,
Yes,
we have not found, we may be incorrect.
yes.
That any pleadings regarding questioning the capability of the or eligibility of the private respondent.
Anyway, my lord, that may not be there.
No, since you
Yes.
are
No, no, my
talking on
lord.
this,
Subsequently, we got to know, my lord. Maybe it was not.
could have filed an additional.
Additional affidavit, right. My lord, lordship will have these documents. Following,
If
my
you
lord,
are questioning, that is also something very
yes,
relevant, but
Yes.
that needs to be a part of the record.
yes, yes. My lord will kindly have this, my lord. This Government of Andhra Pradesh abstract. Now, following reorganization of the Reorganization Act of 2014, my lord, Telangana was carved out of, my lord, what we call it, Andhra Pradesh. Then, my lord will kindly see paragraph number 5. In reference third above, Secretary Andhra Pradesh Social Welfare Residential Educational Institution Society, Hyderabad, has informed that in pursuance of the above instruction, 59 Board of Governors meeting held on Iman has made the following resolution.
You're reading paragraph?
My lord, that 31/5/14
Paragraph?
AM, the 5th paragraph, my lord. 5.
Fifth paragraph.
In reference,
The secretary.
in the reference third read above,
Okay, next one, okay. There are two
in the reference third above, Secretary AP Social Welfare Residential Educational Institution Society, Hyderabad, that is the society, my lord, has informed that in pursuance of the above instruction, 59 Board of Governors meeting held on 28/5/14 has made the following resolution and has requested for approval of the same. It is hereby resolved to divide existing Andhra Pradesh so-and-so society into 2 societies, that is Andhra Pradesh Social Welfare Residential Educational Institution Society for residuary Andhra Pradesh state, that is the present one, and Telangana Social Welfare Residential Educational Society for the state of Telangana. Now, if your lordship would kindly come to the other one, my lord. It's a very much a extended arm of the government of Andhra Pradesh, my lord, Social Welfare Department. Kindly see, my lord, Government of Andhra Pradesh, Social Welfare, kindly see order. In Government Order 8th and 9th read above, government have permitted secretary so-and-so to go for regular recruitment to a 782 regular post of teaching staff, a vacant in the regular schools, and 943 post of teaching staff, sanctioned to regular schools in the government rate with so-and-so basis instead of contract basis by following the procedure. It is very much a part of the government. My lord. So my learned friend Chaudhary made a statement. We do not know whether it is government or not. My lord, lordship knows one thing, my lord. In my lord, International Airport Authority, a question arose whether, my lord, International Airport Authority is can be constituted to be an authority under Article 12. My lord, Justice P.N. Bhagavati, who authored the judgment, he took a lot of pain to write the judgment, and he conclusively held, my lord, that with the passage of time, my lord, the governmental activities increase manifold. Where government intends to lay its hand, but in the name of pure government, it cannot be carried out. That is how this concept of public sector undertakings grew up. So the Honorable Supreme Court said these PSUs, Allah lordship knows in two ways PSU can be made. Either it can be by a statute or it could be registered as a society. So my lord, both are extended arm of the government. Certain functions which government cannot discharge to the bureaucracy. Basically, my lord, it is our whole understanding was government and bureaucracy synonymous. But my lord, with the passage of time, we are seeing hundreds of my lord PSUs having come up. But those are also extended arm of the government. Similarly, this Andhra Pradesh Social Welfare Residential Society is also an extended arm of the government. This rationale we get in that International Airport Authorities. So therefore, to say this is not government is not correct. Now, at the end of the day, what has been asked by the other side? As far as my lord, the government is concerned, government has made a statement that out of the 3 years, 2 years were from government institute, and my lord, 1 year from private. That is straightway it can be, rejected. And second is bank's insolvency certificate is actually in favor of government of Andhra Pradesh, not in favor of the state. Now, as I already submitted, my lord, the requirement at page 82, it is very silent. It does not specify any form of, my lord, any prescribed any form. On the contrary, clause 16.1 of the tender says that employer is within its right to seek clarification. They could have sought a clarification. That clause, my lord, in the tender, page 66. Clarification of bids. During evaluation of bids, the purchaser may at his discretion ask the bidder for a clarification of his bid. The request for clarification and response shall be in writing, and no change in price or substance of the bid shall be sought, offered, or permitted. So there is a caveat also. While seeking a response, my lord, or clarification, what cannot be permitted is to change the price or substance of the bid, because it may have the effect of making a non-responsive bidder or eligible bidder. So as long as that does not happen, it is always open for the, my lord, end of the day, they are administrative authorities. They have no, bias towards any party. All that they want is at minimum price government should procure. And I'm sure, my lord, if my financial bid is open, it will transpire. Lordships can, for a lordship satisfaction, can call for my financial bid and open it and keep it in seal cover. Because my financial bid, I'm sure, my lord, it is much lower than that of the private estate. So at the end of the day, my lord, public interest is in whose side, my? Yes, the Honorable Supreme Court right from 92, my lord, has all, in fact, my lord, the early 80 judgment, Supreme Court did not even, I mean, at the threshold only the examination was done. It was only from Sri Lanka Vidyarthi 91 that the court started examining the violation of Article 14 also at a stage after entering into the contract. So in this view of the matter, my lord, I think it will be very difficult to, I mean, accept the stand of the other side that there is no arbitrariness in the process. When a legible bidder is sought to be made non-responsive, it is violation of Article 14. That's my humble submission. My lord, in my lord 1878, we have made a statement, my lord. 1878. Actually, they filed affidavit only in 1878. There we filed a reply, my lord. 1878. There we have filed our reply, my lord. Para 13, my lord, at page 131. That has your lordship got it? That in reference to the statement made in paragraph 14 and 15 of the A4, from commercial wisdom, I say that being an experienced player in the field, the price bid of the writ petitioner had the potential to be adjudged as the lowest L1 bidder, which should have saved considerable amount of public exchequer, that too with quality supplies. It is, on the other hand, a fallacious statement on the part of the answering respondent that SSA through the instant tender had made an endeavor to receive quality supplies for the students. There has been consistent deviation in the tender clauses historically, which is indicative of favoritism to some selective bidders, including respondent in the instant case. It is submitted that respondent 5 and 6 have consistently been awarded the bid for supply of notebooks every year, despite there being concern in the quality of the notebook supplied. Further, there has been degradation of the technical specification or paper in the instant tender for the year 21-22 as compared to the technical specification prescribed in the tender for the year 2021, which appears to have been degraded to be favorable to respondents. In the year 1920, there were 5 parameters under technical specification for paper. The number of parameters were fewer than industry standard, including as required by the similar tender for supply of notebooks floated by state of Andhra Pradesh, and as is stipulated in Indian standard so and so on specification for writing and printing papers. In 2021 as well, the tender for supply of notebook was awarded to respondent number 5 and 6. In the tender for the supply of notebook for the year 2021, technical specifications are degraded back to the inferior standard prescribed prior to so and so. The quality parameters for the year are expected below. From the above background, it would appear to any impartial observer that an unfair advantage was provided to respondent number 5 and 6 by degradation of the standards it is submitted. The standards here are inferior to both industry standard and standard prescribed in tenders floated by other states such as Andhra Pradesh, as it would appear, and standard are being lowest. My lord, I can just show, my lord. This is the copy we supply, my lord, the blue one, and this is the one my learned friend's client supply. And very well, my lord, go to with the naked eye, one can make out the difference in quality. All is not well in Rome, my lord. So in view of this statement, I can lordship now can direct the, my lord, government advocate to produce the, my lord, price bid of the price bids, and lordships can find for lordships whether what I am saying is correct or not, because we have made an amendment to that effect. So that is my humble submission.
Stenographer, no? There are three petitions for three category of supplies. Just give me the.
Yes. My lord, as far as my lord, the 1877 is concerned, it is for class 6 and 7. This is 6 and 7,
Well, just a minute.
but
One, 8, 7, 7.
My lord, we have prepared a statement, my lord, with regard to the pre-read petition. Lordship can yes.
1878 class 5.
Second.
Okay, class 1, 2 is 1876. 1877 is 6 and 7,
Yes, my lord,
and 1878 is 5.
plus 5.
1 and 2.
And you appear for both Pafna and Pragati.
Yes.
Pragati Paper Converters.
My lord,
PP Pafna Ventures.
my lord.
Pragati Paper Converter is, what are you?
My lord, it is a, my lord, partnership.
Partnership.
concern.
Pafna, I don't think he appears. Mr. Mohondo appears.
Bafna, my lord, my colleague, my lord, he appears.
Oh, you have not said anything. Huh? You have to say something at least. Whether you endorse the views of Mr. Chaudhary or anyone from this side. We thought Mr. Barbadari was appearing for all the private respondents.
Well, 7 except Bafna, my lord, in that case.
That means in 1876 you are appearing.
Yes.
Private respondent number?
Private respondent number, my lord, it will be 5.
R5
R5, my lord.
in 1876.
Yes, my lord.
Yes, anything? What is your bid? He's on a different category. Have you filed affidavit?
Yes, ma'am.
You filed affidavit?
Here, not.
Do not file affidavit.
That only 3 interlocutory applications has been filed. Already none of the read petitions, my lord, the private respondents has filed affidavit. So only those interlocutory applications, there we have, my lord, pleaded our stand.
One is I,
You had filed IA 2718, 2022
yes, ma'am.
for release of the amount.
Amount.
Heard. Internet.
Lordship, with regard to the clarification given in respect of page 50 that society annexure where they have supplied. Lordship, those two documents that has been produced today, Lordship may kindly take up the one dated 31/5/2014.
Yes.
Lordship, the second page,
You want 31.5.
31/5/2014
Yes,
dated.
yes,
Lordship.
second page.
Second page, clause number 6.
Hmm.
Lordship, the Secretary APSWRES Hyderabad has requested the government to approve the bylaws for both the societies and accord permission for the registration of the new society. Lordship, still it shows that it is not a government or semi-government. Maybe some funding is there. Lordship, maybe some funding or nominated members may be there. Lordship, but it doesn't say-
Read seven, government
Doesn't say
after
that it's-
hereby
yes.
approves.
Lordship, there may be some controlling, but it doesn't reflect that it's a semi-government institution.
Where have you filed affidavit in this regard?
Lordship, these two documents are produced today.
Where is the
Lordship,
affidavit
Lordship,
of
may I
the
give it
state?
one day.
Where is the affidavit of the state saying all these things?
Lordship,
Because
this
you
has been,
made oral submission, that's why I brought it.
Lordship, oral submission first was made by the senior council stating that the state level purchase committee ought to have considered that annexure, Lordship. Against that today, against my submission today,
Okay,
senior
wait,
council
wait.
has brought this to
Yes,
the,
wait,
Lordship,
wait.
may give me an opportunity, I will file an
We'll
affidavit. to
consider,
that
we'll
effect.
consider, okay. Heard Sri K.N. Chaudhary and the senior council for the senior council assisted by Sri R. Chakraborty for the petitioners in these cases. Also heard Sri B. Chaudhary, Senate Standing Council, SSA, for the Sarva Shiksha Abhijan. Sri R. Bharpujari has appeared for the private respondent in WPC 1878 and 1877,
My lord.
whereas MS PR Mohanto has appeared for the private respondent in
1876, yes, my lord.
2022.
My lord.
The hearing is concluded. The judgment is reserved. You're appearing in this matter.
In last occasion also I appeared when they have taken time. Meanwhile, madam, there was some this thing, so I had to go out. And they, Raj Agarwal
But
appeared.
yes, yes.
He is with me.
But we had done a substantial portion of the hearing. We had
I-
completed a substantial
What-
portion of the hearing. Where is Mr. Kulita? Oh, yes. We had almost done,
My lord, I think, my lord, the entire fact,
Hmm.
the entire fact was not placed. Because he says that there was some half an hour time and both sides said some. Now, if I have to appear, my lord, if your lordship permit me.
No, definitely, we'll hear, but there's no question of not hearing you, but we thought that we had completed substantial portion.
No, I'll come to that, man. But first, let me place my case, then I'll come to the negativity which has been projected from the other side. There is no escape for me, I have to meet. No, my lord, if your lordship has heard it, your lordship is aware, my lord, that the petitioner is a manufacturer of fired clay, soapstone powder, etc. And he, my lord, he imports his raw material from Meghalaya. Now, my lord, we are before your lordship because the disbursement of the transport subsidy has been stopped, kept in abeyance after it was approved by SLC and the money for that was sanctioned to the government of India. So it's not a case where the competent authority has not approved. The competent authority has approved. The government of India has sanctioned money. Meanwhile, at the instance of the Squadron number 3, that is Commissioner of Taxes, this is being withheld. And we are before your lordship against that withholding of this. Now, if I may say, my lord, at the relevant time, there were two schemes in vogue in Assam. This will be very relevant, my lord. One was Assam Industry Tax Exemption Scheme 2009. This is Assam State.
Assam Industries?
Assam Industries Tax Exemption Scheme 2009. I'll get the copy. I'm referring this because subsequent event, pending disposal of this, my lord, writ petition, this has happened. That's why it will be relevant for me to make my submission on this. Now, your lordship will keep it aside. I'll make submission at the relevant time. And the other was, my lord, Transport Subsidy Scheme 1971, which was extended from time to time. Now, the petitioner was entitled, my lord, or is entitled to receive benefit under both the schemes. But he was being denied at the instance of the respondent number 3, that is the commission. Under both the schemes, he was being denied. Now, the objection is the first objection of the tax department. And it came subsequent to, my lord, the approval of the SLC. And the first objection was, we are not a manufacturing unit. This was the first. And the second was, the claim of the petitioner for purchase and transportation of raw material from Meghalaya to his industrial premises is bogus and false.
Correct.
Requirement of manufacturing is common to both the schemes. Under the tax exemption scheme also, it is only manufacturers who have been given tax benefit. They will pay only 1%, my lord, and rest will be exempted. And as the transport subsidy is also meant for the manufacturing. It is there and I can show to my lord. My lord will kindly take up the tax exemption scheme 2009, which I have given here. I've given.
Of the scheme, yes.
Yes, that's what. My lord, if your lordship will kindly see paragraph 2.
Page?
Second page, my lord. Don't even page in it.
Definition.
Definition. Category A, new unit which manufacturer goods in Assam and has commenced commercial productions on or after 2008, but
up to 30th September 2013, as in compliance with the eligibility criteria under the scheme shall be treated as an eligible for benefit under this. So it's only, my lord, the manufacturers. There are ABC categories of the manufacturers. I'm showing this for the time being only for them. Now, if my lord will see page 176 of the paper books, there your lordship will get the transport subsidy which has been annexed at page 176. Page 176 of the pleadings, my lord, of the writ petition. Writ petitions. Page 176 below. Not paper. I have compiled all this.
Is a
Pleadings.
contribution number is
Yes.
separately filed.
But no, not separately. It's continuation number. 176, my lord got it.
There is no
We have taken it from course. Page 176. I'll place it, my lord. Paragraph 3, if my lord will kindly see. It is applicable to all industrial units. My lord got it. Barring so and so, so and so, so. Now your lordship will come to 4. A, industrial units means an industrial units where a manufacturing program is carried out.
Mr. Kolta, you have some difficulty?
So actually, Lordship, this when the additional affidavit, this was filed, so continuation page addition was not there. So now it has become little bit difficult for us to like, because it was separately paginated earlier.
No, nowadays we get a consolidated page.
Yeah, so like we don't have that continuous, but anyways, Lordship will.
Page 87, I can give you of my additional affidavit, but it will be difficult all the time to tell you. Because we have
No, thing is that like when it was filed, this one copy should have been served to us. with
This
the
is paginated by the office.
No, when it is filed, then continuation page has to be given. And after continuation page has been given, then copy is to be served to us.
You can just.
Yeah, we can refer it to Lordship, not an issue.
I'm just.
Not an issue, not an issue.
Yeah. There.
Filing.
Any visitor to Hoboken? I also don't have. Put it done.
See, the affidavit in reply starts at page 88.
Earlier I had made that way, but when this is.
And the actual
Page 87.
pleading starts at those are, index and all. The actual affidavit in reply by the petitioner starts at page 90. You can start from 90. So that way, you'll get 176. 176 in internal page 87.
Yes, internal page 87. May I, below?
Yes. Clause 3. Clause 3.
Yes,
Clause 3.
clause 3.
Yes.
Clause 3 is applicable to all industrial units. This scheme is applicable, my lord, to all the industrial units. And definition 4, A, if your lordship will see, industrial units have been defined.
Definition.
4A. Industrial units means an industry unit where manufacturing program is carried out. So all that I'm saying is the requirement of manufacturing are common to both the schemes, tax exemption scheme as well as transportation scheme. And the objection was that we are not a manufacturer. We are not a manufacturer.
Yes.
If I'm not a manufacturer, then obviously I'll not be entitled under both the schemes. Now, my lord, the events which has taken place pending this writ petition shall be very relevant and which I will be placing before your lordship. My lord, under this scheme, the the tax exemption scheme. My lord, the requirement is that eligibility certificate will be issued by the industry department. And after the eligibility certificate is issued, the Commissioner of Taxes Assam will issue entitlement certificate.
And
Entitlement certificate, and only after that, an industry will be entitled to receive the tax benefit under the scheme. Now,
first eligibility certificate is by the industrial department,
that is eligibility
then
certificate
entitlement certificate by
the Commissioner of Taxes, Taxation Department. That is called entitlement certificate. And my lord, even if the eligibility certificate is issued by the industry department, still the Commissioner of Taxes will have, my lord, discretion to even refuse entitlement certificate. And once the entitlement certificate is refused, the industry will not get the benefit under this. Those things are there on 4
the
and 1.
Commissioner of Taxes has the discretion.
Yes, he has the discretion. I will show, my lord. Your lordship will kindly turn to page 6 of this scheme. Page 6
Of
of the scheme. Exemption scheme. Page 6, internal page 6. Lordship button. Now 5.2, if my lord will see, issue of certificate of entitlement. Five Roman.
Yes.
I'm placing Roman 2, my lord, 5. On receipt of the application for grant of certificate of entitlement from the eligible unit holding eligibility certificate granted under this scheme by a competent authority, in the case of micro enterprise, the concerned assistant commissioner of the superintendent of taxes having jurisdiction over the unit, and in case of a small and medium large scale unit, the commissioner of taxes himself or through officers subordinate to him shall examine as to the correctness of the particulars furnished in the application and the documents accompanying therewith. And after making necessary check, your lordship will kindly mark it. Here the discretion lies. And after making necessary checks, if the commissioner of tax or the concerned assistant commissioner of taxes, superintendent of taxes, as the case may be, is satisfied that information furnished in the application is based on the information contained in the eligibility certificate granted to the unit concerned, and any further information furnished in the application or in connection with it, is correct, he shall grant certificate of entitlement to the eligible unit. So the registration is there. Now, my lord, in this case, due to interference of the respondent number 3, who is Commissioner of Taxes, the industry department was not giving me eligibility certificate. If I don't get eligibility certificate, there's no question of getting entitlement. So I approached your lord. There were 2 rounds of litigation. And ultimately, my lord, the eligibility certificate was granted following order dated 19/8/2021. 19/8/2021, passed in WPC 5623 of 2017. This is annexure F at page 133 of the paper book. I'll just give you the internal page. Just give. Internal page 4. Yeah, I need not take your lordship because this is closed chapter. I just want what has taken place. Now, meanwhile, my lord, what had happened when things were pending before your lordship, this court, the commissioner taxes made assessment of VAT amounting to 42 lakhs against me. The process of recovery was set in motion by issuing recovery certificate. My all bank accounts were freezed, was frozen at their instance. At that point of time, my lord, your lordship asked the commissioner of industry to pass a speaking order. Thereafter, because commissioner is also not the authority. Thereafter, my lord, the commissioner with his recommendation placed it before the SLC, state level committee. State level committee approved that I am entitled to receive the eligibility certificate. And thereafter, my lord, the eligibility certificate was issued to me. I'll place that at page 142. Journal page 50. My lord, got it?
Yes, yes. It's 142.
Internal page
142.
53. my lord.
Is either is 142.
140. Section. Certified that Messrs. Narayani Mineral, the petitioner Miller, so is granted eligibility certificate for incentive under Industrial Policy Assam 2008. It should have been 2009. And claiming exemption of tax under the Assam Industry Tax Exemption Scheme 2009.
The earlier answer should be 2009.
2009, well, actually this policy was conceived in 2008, but the scheme came in 2009. So this was
Is
issued,
it called 9 or 8?
well, 9. This is 9. And Industrial Policy Assam is 2008.
8.
Correct, yes.
Then this is correctly done then.
Yes.
So far as the initial policies come, the 8 of
Yes.
examination is 9.
Yes. Now, once this was issued, the commissioner, your lordship has seen, the commissioner has a discretion, he can check, can verify the facts. And he may refuse if something comes up. But the commissioner also issued entitlement certificate. My lord will get entitlement certificate at page 144. 144. Internal page 55. I place it below the lordship. This is to certify that the unit in the name and style of Narayani Minerals so and so under the Assam Value Added Tax 2003, holding eligibility certificate dated 4/3/2022, is entitled for exemption of tax in accordance with the provision of Assam Industry Tax Exemption in 2000. So this was granted by the Commissioner of Taxes. Then what is interesting is the follow-up action has taken. Follow-up action, your lordship will get at page 182. 182. Internal page 93. Internal page 90. Page 182.
Internal page?
Well, internal page 93. This is
That is correct.
yes. This is addressed to Superintendent of Taxes Recovery by the Assistant Commissioner of Sales Tax. This is dated 7/4/2022. I have the honor to state that the office has received eligibility certificate from the Commissioner of Industries and Commerce Assam as well as in entitlement certificate from the Commissioner of Taxes. Hence, I withdraw the area certificate issued for realization of demand dues of Narayani Minerals for an amount of rupees 42,24,887 for a period so and so under the VAT Act. So the recovery certificate was withdrawn. And thereafter, my lord, I'll just place one. Later, we are sent to the bank to defreeze my account. Because your lordship will see from here how much I have suffered. Now your lordship will kindly turn to page 183. This is addressed to, not take your lordship's time here, it is addressed to Branch Manager, Union of India. The last but one paragraph. Henceforth, on the basis of above, I am waiving the restrictions imposed on withdrawal of account number so and so. Likewise, my lord, the next page, the letter is addressed to State Bank of India. Page 184. 83 I have shown, my lord, Union Bank of India. Then State Bank of India. Similar contents, my lord, last but one paragraph, if your lordship will see, henceforth on the basis of above, I am waiving the restrictions imposed on withdrawal of account number so and so. Then the next letter, the last one is State Bank of India, Fancy Bazaar. This is South Guwahati and then other is Fancy Bazaar. To similar effect. Now, my lord, it is settled now that I am the manufacturer. I am a manufacturer. That is how the tax exemption was granted by the industry department as well as the taxation. Now, if I am a manufacturer and I have been assessed to VAT, question arises from where do I get my raw materials? Is it available in Guwahati? That I'm getting it from Guwahati, producing finished product and selling it in the market. There is nothing on record to show that the raw material that I import from Meghalaya is also available nearby, and that I'm making a false and bogus claim of importing it from. There is nothing. So the second objection is that claim of purchase and transportation of raw material from Meghalaya to Tapatoli in Assam is false and bogus. In fact, my lord, has no, it's a made up story, and it will be obvious, it will be writ large on the face of record if I place. Now I come to the transport subsidy, which is subject. But during pendency, my lord, your lordship will see this writ petition, the present writ petition 1517 of 2019 was filed on 27/2/2019. 27th of February 2009. And the eligibility certificate was given to us on 4/3/2022, and the entitlement certificate was given to us on 21st March 20. So this is subsequent to the filing of this writ petition. Now, we were expecting, my lord, that now the Commissioner of Taxes would not object transports, which he has objected earlier by filing. That was our expectation, but it was not. Now, who are the person who are objecting? But this will be very relevant when I place the Supreme Court decision on the point. If my lord will kindly turn to pay order dated 16/11/2020, passed in this case. 16/11/2020.
Sixteen eleven.
16 November 2020. Opinion. time.
In 1517 itself.
Yeah, 1517. It is marked, but we can have, we have downloaded. Don't you got it? Otherwise it is here.
2020.
Yes, 2020.
Yes, yes, we have.
Yes. The second paragraph, my lord will kindly see. The case projected by the learned senior counsel for the petitioners is that the respondent number 5 had been told disbursement of the subsidy amount on the alleged claim made by the Commissioner of Taxes. This so-and-so learned standing counsel for the industry department is present. He submits that as per his instruction, the respondent number 1 and 2, I will kindly mark it, do not oppose this application. Respondent number 1 is government, represented by Secretary Industry, and respondent number 2 is
Commissioner
and the
Taxes.
respondent number is my lord Commissioner
Commissioner
of
Taxes.
Industry
Hmm.
and Commerce. So they do not have any objection. They have no claim against the petition. Accordingly, in view of the said instruction, respondent number 1, 2 are exempted from filing.
Filing affidavit in opposition.
Yes, they are not filed. However, it is seen that despite taking adjournment on 16/12/2019, the Finance Department has not filed any affidavit in opposition. Accordingly, the Finance Department is also put to notice that why the court should not revoke doctrine of non-traverse and deem that the state has admitted the claim of the petitioner and pass appropriate order on the next. Because the lordship is aware the government has to speak in one voice and not different voice by different departments. So here is a case where 2020 respondent number 3 was objecting, and after the subsequent event which taken place and he has himself issued the entitlement certificate on 21st of March 2022, we expected that my lord he may not object, but it is not. He continues with his objection. That's why this carry. So now I come to my lord the transport subsidy. My lord,
How do you reconcile this statement?
Lordship,
The recording by the court,
the Lordship.
1 and 2
Lordship,
do not oppose this.
that particular date, Lordship, what has happened is that the entitlement certificate and these certificates were issued.
Eligibility entitlement too.
Certificates were issued. Eligibility certificate and entitlement certificate is basically specific to the tax exemption part. And this has been issued by the state. So I didn't have any objection to that. That's what my submission before this honorable. So I didn't have any objection to, because this has been issued by the state only because there was a litigation earlier, as my learned senior has already stated. So whether it was a manufacturing unit or not, that has been decided and the speaking order was passed stating that this will be a manufacturing unit, though it will not be treated as a precedent that has been stated there. But anyways, it has been stated that it is a manufacturing unit. And subsequent to this, Lordship, because since it is an eligibility unit and under the Assam the tax exemption scheme, so if it is a manufacturing unit, then they will get a tax exemption. That is what stated, and accordingly, entitlement certificate was also given. So that is
So
what
if you are not raising any question or other accepting the submission, then what has transpired, what we remember from the earlier hearing,
Lordship.
that bogus the claim for bringing
So that is yes, Lordship.
for bringing raw material from particular some dates, there is no recording. You had said that the records do not show that any movement was there.
Correct.
Transport movement was
Correct.
there. And then those if you say
So
that you are
two
not.
committees reports were there because Lordship, only because the entitlement certificate is given, the transport subsidy they may not be eligible. Because eligibility certificate and entitlement certificate, these two certificates are basically it's for the tax exemption part.
So there are two connotations. One is eligible. That means we hold you to be eligible.
Lordship.
And one is entitled. That means you are entitled, you should get. Now, once you issue the entitlement,
No.
eligibility is the first hurdle. You will not be entitled unless you are eligible. First, you enter the arena, become the eligible. Now, once you are held to be entitled, then thereafter objecting.
The entitlement for what, Lordship? Entitlement for tax exemption only, not for transport subsidy. Transport subsidy is different, Lordship. It has to be, it has to be evaluated
different.
in a different procedure. It has to be evaluated in a different procedure. There is a
The
checklist.
entitlement only for tax exemption.
Tax exemption, Lordship. It's not connected to transport subsidy. That initially, Lordship, as far as the tax is concerned, sales tax is concerned, an eligibility certificate will be issued by the SLC after the approval of the SLC by the Industries and Commerce Department, stating that he is eligible for this much of tax exemption. Then they will go before the superintendent of taxes. Superintendent of taxes will examine it, whether it is there, this whole eligibility they will get, or like what will be the quantum of entitlement. And accordingly, they will decide on quantum
As
of
far as transport subsidy is concerned.
transport subsidy is concerned. There is a separate scheme here, Lordship. Under the scheme, there is a checklist given by the central government, and as per the checklist, we'll have to check whether the transport subsidy, the amount has been transported or not, the amount, whatever the
Whether the unit has met the requirement of the checklist.
so checklist, checklist has to be
Whether
there,
the
and
unit has met the
there-
requirements.
and if required, there has to be, the power is there to do some inquiry whether if
So
there
this,
is a,
this list is pertaining only to transport subsidy,
yes,
not
yes,
to tax benefit.
not so taxes.
So you can straight away come to the transport
So
subsidy
tax,
part.
tax is different, dear Lordship. Tax doesn't have anything to do with this. Eligibility certificate is given for the tax. Eligibility certificate, entitlement certificate is
So,
given for
Mr.
the tax.
You can address straightly on the transport subsidy part.
No, my lord.
If tax is not the issue involved.
Your lordship, it is settled already. I've said. Thing I have said. And this is a subsequent event which I have brought to your lordship's notice. An order dated 1611, which I placed before your lordship, has got nothing to do with the tax exemption. It is in this writ petition that has been filed. And they say they don't have any objection against the writ. Your lordship will read it again. 1612 has got nothing to do
With tax.
with tax.
No,
16
One second.
sorry, I'm sorry.
One second. Let me understand.
1611,
Because he's making an emphatic statement. Let us see the meaning.
1611, if your lordship will see the order, give me the order. This is passed, the first page of your lordship will see, 1517 of 2009. This is the order. And this is the case.
Mr. Kolita, see, the entire writ petition is not only structured but projected only for a sum of something for on account of transport subsidy.
Yes.
Correct.
Nothing to do with the tax.
No, Lordship, what has happened, they subsequent, after filing of the writ petition, and subsequently, very recently, they have filed two affidavits. One affidavit in reply and one additional affidavit. And in that additional affidavit only, they brought out these facts, Lordship. As far as getting this, these are subsequent events, Lordship. So they have got this, the speaking order was passed in 2017. Then, Lordship, this 2022, this entitlement certificate was given. Then, Lordship, these issues, I mean, like these facts were brought into record very recently, Lordship, by filing the additional affidavit. And in that context, Lordship, that statement was made that these, as far as these two things are concerned, entitlement certificate as well as eligibility certificate, there is no issues because that has been given by the state. But this is a separate issue, Your Lordship. So I'm sorry, Lordship, like if I could not communicate it properly, Lordship.
Let us come to the prayer again of the writ petition at page
So
12.
Lordship will see that it's additional affidavits. and
At page
affidavits were
12,
filed
at page
subsequently.
12, at page 12. It is only pertaining to the transport subsidy.
Yes, transport
For
subsidy.
1,77,38,000.
Transport subsidy, Lordship, but the way my learned senior counsel has now connecting it with the transport subsidy as well as the tax
Tax
subsidy. So
component.
these factual things, Lordship, which has been filed, this is filed on 19/4/2022. And another one is filed very recently, Your Lordship, on 14 March 2023. As far as subsequent events are concerned, Lordship, may kindly take.
14 March.
14 March 2023, Your Lordship. So here, Lordship, lot of facts have been brought out regarding that. The transport subsidy scheme has been given, then the affidavit in reply only, Lordship, they have brought out these things on board about this entitlement certificate as well as eligibility certificate. So these were very recent things, Lordship. These were not there before in the writ petition. So they have filed it by way of a reply as well as an additional affidavit. So in that context, Lordship, the statement was made that eligibility certificate as well as this entitlement certificate are concerned. I don't have any.
I think the last affidavit is on 10/3. Thereafter, we had heard the matter on 14/3.
The 14th. 14th.
I think that
I'll
is
just-
10/3, I think 10/3. 10/3, 14/3, 14/3.
The Lordship, this affidavit was filed sometime in February 2022. This is Lordship,
One has been filed on 1st of March, 2013.
second year also.
One has been filed on 10th of March. First March is against Responsible 6.
Is correct, Lordship, correct.
10th March is against Responsible 6.
So after bringing these facts before the court, then only that submission was made, your Lordship. So this was filed in September 2022. This additional affidavit, your Lord.
Which one is was not- Do not oppose.
So as per my, these copies are concerned, Lordship, this affidavit in reply was filed in April 2022. Sometime in April, date is not there. And this additional affidavit was filed in September 22. So these facts were brought on record later on here.
No, there is a clear statement made after that. And court's observation. Do you have a copy of the order? 1611,
No,
2020.
my learned senior has read out.
No, you have a copy. It makes a lot of sense, in fact. We have an extra copy.
Lordship, permit me for a second.
Yes. No, I'll come back to you.
Yes, on 1611, in this context, this order was passed by Justice Surana. 16/11/2020.
2020, that's
That
right.
time there was no, the affidavit that he's showing was not even there. This is a subsequent event which is, we are bringing out, we are duty bound to bring it before a law. Because order dated 4/3/2016.
Third paragraph. And for that reason, the court not only had considered the aspect, but applies its mind saying that you need not.
And
you
exempted
not
them
even-
from
you not
filing
even
AO.
file affidavit.
Yes.
See, unfortunately, that day I was not present.
No, we are not on the person who was present. And there was no necessity at all. It came from his own, that he has instructions. You consulted instructions, what instructions was there? Were there?
I'm extremely sorry, Lordship, like this, as far as this order is concerned, I was not aware. I was thinking about the other order, Lordship.
No, exactly. That is why. The moment senior counsel has
Yes,
pointed out.
I'm extremely sorry. My apologies. I should have gone through this, but Lordship, I was not aware of this order, your Lordship. But as far as the other order is concerned, that's what I was submitting, that lordship, these facts were brought on record later on.
We are not connected remotely with, also with the,
Correct, correct. So,
we are only connected with transport subsidy.
correct, lordship, that other order, lordship, was passed earlier. So in that order I was referring to, not this order. Lordship. I was not aware of this.
Another order is 912, that's our more clear. Your lordship.
2020.
Yeah, 2022. 2022. Before your lordship.
This is probably I'm referring to.
Yes.
Yeah, this was I'm talking about. like, lordship.
912.
And this, now read your, with this, if it is read with 16/11/2020, it will be very clear. That what is the stand of the industry department? Second paragraph, my lord.
Of which order?
9/12/2022.
Yes, yes. Only a small clarification is required.
Yes,
So this order, this
It's
I
almost
agree, lordship, I
resolved.
was there.
it's almost resolved. Only a small clarification is required. From corresponding department in the central government. And the B. Gogoi is standing for taxation department. He said there are certain objections. So these objections pertain only to, and I will show my lord, your lordship, the entire fact is not before your lordship, even on transport subsidy. The entire fact is not before your lordship. Please permit me to bring all those facts. Even the tax department will stand nowhere, my lord. Let me just bring those facts. My lord, those facts are so glaring on the face that your lordship will see that so much injustice has been done to the petition. Let me just bring those facts.
Yes, lordship.
But the other day, if you remember, regarding the anomaly or what they say,
I will come
fraud.
to that anomaly.
Fraud,
That anomaly-
no, not anomaly. They had gone to the extent of alleging fraud in making
Filing-
false vouchers.
Yes, filing an FIR. Then
Yes.
there was a final report and the
Correct.
case was closed by the magistrate on the acceptance by the tax department, Meghalaya. I will come, my lord. I'll show everything. There's no escape for me. I have to meet that point. Whatever point is raised. Therefore, my lord, I'm sorry, my lord, to say, but then that day, fortunately, there was some bereavement in my family. So I had to go. And my learned friend started, then he started, and then those things were brought in. But if, without considering the entire fact, if some negative things are brought out, certainly, my lord, it will disturb your lordship. Your lordship will think there is something, why they are not addressing. But I will address those. Because unless I address those, I cannot get an order from your lordship. That I know, but your lordship must know the entire fact.
You're correct.
As far as lordship, this taxation department is concerned, they have stated, they have filed an affidavit in
That
2021.
I will refer to everything.
So they have stated about their objection, whatever is there.
Yeah, I'm
So
going to
taxation
place-
council is not there, but.
I'm going to place that. Everything will be placed.
Who is for taxation? You ask him to come, ask him his presence will be required. The other day he was there in the hearing.
Yes, lordship, he was there, lordship.
Still we have 15 minutes, I can continue.
Yes, please.
Now, my lord, so far as transport subsidy is concerned, even here, the authority is state level committee, SLC. And the procedure in vogue, and procedure in vogue, very shortly, I'll state, my lord, what are the procedures.
Yes,
Well, the first, a claim will be made for transport subsidy
sir.
before District Industries and Commerce Center, DICC. This will be made by whoever is claiming. He will make a claim before them. That claim thereafter is forwarded to the sales tax department for verification and authentication of the purchase and transportation of raw material to the factory from wherever he wants to purchase. Here in this case, Meghalaya. The third step is tax department, after it receives, my lord, a request for verification and authentication of the claim, it submits its reply. Its authentication report, it submits to the industry department. And thereafter, that is placed before the SLC with a recommendation of the industry.
Industry department.
Yes. And after the claim is approved, then it is sent to the Government of India for sanction of the money. So these are, my lord, the 4 steps which are taken to initiate, my lord, the transport subsidy. Now, in this case too, the petitioner, my lord, submitted its claim for DICC.
When?
This was submitted on various dates from November 11 November 2011 to
District Industries?
this District Industry and Commerce Center, DICC, in Bamuni Maidan.
First you have to submit the claim.
Yes. So claim was submitted on different dates. And in this case, my lord, we are concerned with the claim with effect from 11 November 2011 to 31/12/2011. 2012, I'm sorry, 2012.
Again, give the period.
11th November
2011
to 31/12/2012. This is the period which is involved before your law. This is the period. Now, once the industry department sends it to my lord, the sales tax department, here in this case, they submitted their report, the superintendent of taxes. And we fall under the jurisdictional superintendent of taxes, unit B. Because the entire, my lord, this was initiated by a superintendent of taxes, unit D, who is not my jurisdictional superintendent. Now, the superintendent of taxes submitted authentication and verification report. The first one was on 25/4/2013. 25/4/2013. And this, my lord, will get at page 225. The paper book. 225. This was submitted with our additional affidavit. Journal page 39. My lord, got it. This is addressed to Commissioner of Taxes, Assam. Report information was so and so in respect of Messrs. Narayani Minerals.
You are reading 225.
225, yes, sir.
Oh, there are 225. Okay.
225.
Is it a letter of 14th of November?
No, 25/4/2013. Internal page 39, my lord.
39, 226. There are two markings.
Yeah, 226, and I have actually 225 and 226 both.
224 is also written here.
224 is, I will come to that, because 224 is.
No, even 224 is also written in the same page.
Well,
It's got three.
No, it's not. 224 is different.
It's got three paginations, unfortunately.
Well,
226,
1, 2, 3 pages.
226, 39 and 224.
Oh, pagination, how do I argue? My lord, internal page
39.
39. 39.
Hmm.
This is addressed to Commissioner of Taxes by the Superintendent, Unit B, Guwahati, our jurisdictional Superintendent of Tax. With reference to above, I have the honor to submit a report as per Annexure A in respect of Narayani Minerals regarding the purchase of raw materials, namely white plastic clay, non-plastic clay, semi-plastic clay, and also sales of finished product, that is fire clay, during the period 11/11/2011 to 31/12/2011, after verification of the office case record and books of accounts of the dealer, which includes sales and purchase record. Then the next page, if my lord will kindly.
That is the report.
Yes, no, report is the next. page.
Annexure
It is
A.
Forwarding.
Annexure A is report.
Annexure A, yes. Now your lordship will see, this is the purchase of raw material. The details are given by the superintendent. Now, on the basis of this, if my lord will kindly turn to page, internal page 38.
Earlier page.
Yes, the first page. This is a letter by the Commissioner of Taxes. Spot number 3.
Hmm.
Now, he
Oh.
writes it to Commissioner of Industry.
Dated.
Hello?
Date.
Date 13 May. Report is of 24th April. He forwards the said report on 13/5. Your lordship didn't get?
Some problem.
Well, then let me do the pagination. They will also.
No. There's not only pagination
Well,
problem, there is
because
jumbling of pages, I think.
this, I think this is what they have
Mr.
noted.
Prasad,
from the
there's
record.
jumbling of pages, 38 has come before 37, I think. Just see the pagination, 37, then prior page, later page. What is this? 30?
Well,
No, just this. We can correct it, no problem.
224 is 38, 13/5. ठीक है sir? 224. Somebody, well, there are two paginations.
And then 38 has come before 37,
Yes,
internal.
Yes, that is originally it was like that. It just place it, not in a chronological manner. That's why I'm making my submission. I have first referred to 25/4, 2013. Then
No,
the
even
last-
the pagination, while making it,
No,
38 has been paginated first, then 37 has come.
Yes, internal page is wrong. Yeah. So we will correct it. Sorry.
Now we can, but this, can do the correction, then we can, I think that will make things easier. Otherwise, Mr. Kolita, you can also have a look at the course file.
Lord, sir.
Make your file in the same
No, I have
pattern.
to do that, Lord, because
Other
a lot of,
respondents also.
Reference is becoming problem.
Oh. So
Even-
now we are in the track, we can easily complete now.
Yes.
Now, since it's come to the status of the stage of the report
Yes,
on the entitlement,
yes.
then I think matter is not take much time.
My lord will take 2/4, no? 2/4. Page 224 is correct, my lord.
No, ইয়াতে দুটাৰ ভিতৰত marking কিয় আছে? 2 আছে। তো এইটো কোনটো? এইটো কি? আমাৰ এইটো কোনটো? আমাৰ correct কোনটো? এইটো নেকি আমাৰ? No, ইয়াতেও এটা ভুল হৈ আছে। 32 আছে, 37 পিছত আহিছে। নম্বৰটো অসুবিধা হয় নহয়। আৰু যদি ইণ্ডেক্স বিলাক মাৰ্কিং কৰিব নালাগে, ইণ্ডেক্স বিলাকত মাৰ্কিং কৰিব নালাগে। একচুৱেলি যদি কণ্টেন্টছত মাৰ্ক কৰিলে ইণ্ডেক্স এটা দুটা পেজ থাকিব, চিনপচিছ পেজ কৰিবই নালাগে এইবিলাক। এই করে mark করে দিব নাহলে। Affidavit এর একটু mark করবো, এটা করার নাই এখন, ঠিক আছে? এইটার উপর করবো, ঠিক আছে, ঠিক। এটা করার নাই, ঠিক আছে? কোড ভুল হয়েছে। নোটিশ কোনো পেশ করেছে স্যার। এই নোটিশ হবে। করা নাই কিন্তু। ঠিক। কোড গন্ডগোল হয়, ঠিক তো আছে এটা। এইটো হলো এই প্রবলেমটা। 74 ইন্ডেক্স আহিল। এইটো আহিব নালাগে। এইটো আহিবই নালাগিছে। হয়তো নাই আৰু কৰিব লাগিব।
So can it be on some, Lordship, can it be on some other time? Then we can correct it, like my learned senior.
So this will require some careful examination, not only correction,
Yes, Lord.
some pages are also jumbled.
So once that court record is properly corrected, then we can copy it from there, then both of us will have the same numbering. Sir.
Otherwise, as I proceed, it will. Hindrance
If
like
Mr. Misra is agreeing, then we don't have problem. We don't want to give him extra burden of coming. Of course, we'd like you to come to the court. That's not the
We all like to learn.
Thursday then, Thursday, Thursday.
Thursday, well, little accommodation will be required, but
Yes,
your
yes,
lordship will take.
Thursday case.
Another matter is.
Thursday case.
But tomorrow, if the office permits, whether my junior will go and.
Today itself you do it. Today in the court, settle it out. That's why you are not having today. In the entire break, you make it. And not only you.
Lordship, I'll also.
Lordship, what's up?
I can just indicate one thing. The affidavit which has been filed by Mr. Gogoi of response number 3, the problem has started from there. Index has also been marked. Normally what is this index is not paginated.
Yes, yes.
So once it has been marked and later on there is some jumbling of pages.
Yes.
So, Malad, the first office will correct, then we will correct or.
So once court record is corrected, Lordship, then we can.
Now, if you are having the same numbers, I'll not have a problem.
No, we.
You can refer to internal page or something, we can have it. But if you make all the paginations the same, you not need the assistance of the office. Only ensure that the page which the court records have and you have is the same. It's only to facilitate the hearing.
So we will.
Nothing sacrosanct about it.
Then we can.
Yes, yes.
Do it in the.
Mutually do it.
During the break.
Mutually do it. Heard. TK Mr. Senior Counsel for some time. Also heard also heard Senate Counsel for the also heard Sri A. Kalita. No, also heard no. For time the Senate Counsel for the respondents are present. It appears that there is some technical issues concerning the court records for which some time is granted, as for which the matter could not be taken up in its entirety. Puts the para as agreed to by the parties, list for further hearing on
Thursday.
Thursday.
Small submission. I request for five. Lordship, our affidavit is on the.
We have no
petition
claim
contain-
against NDA.
No, Lordship, the writ petition only contain page 7. Other document like external document, additional affidavit, you can never serve. You may serve, Lordship.
Give copies upon them. No, Mr. Agarwal will ensure, don't worry. You can just ask him. He will give.
Missing, my lord, is submitted. If my lord,
Give him, give him, give him.
So he may not be having copies because there are a number of respondents.
We'll give him.
Never raised issue. Now, that conclusion of the hearing now, he's raising.
Not conclusion.
We'll give. No issue, we'll give you again.
Puzzle, which space
to
rely, which space not to rely.
You also be in the pagination part. Whatever you don't have, ask Mr. Agarwal, he'll definitely give you.
I'll give you.
And
open petition of page number 21, IM 31.3. Act to her.
this is item number
32, 33.
Yes. 4 dates here will be important. Start. And on the last occasion, your lordships had already noted down. First date is the date of the tender. 30th of June 22. The stage 39 of the first writ petition.
30th of
30th of June 2022. This is in regards to drilling of 3 rigs in Assam and Arunachal Pradesh. Subsequently, there were certain amendments made in which the NIT was extended the date to 4th of August. The date next is 1st of August 2022, when I amended my memorandum of association. Now, the memorandum of association is the initial document created when my company was created. So on 1st of August, I amended my MOU. After that, your lordship, is 4th of August, where I submitted the NIT in terms of the amendment that has happened, which was approved by the shareholders. Now, the requirement under the Companies Act is, your lordship,
now your initial NIT was 36.
36,
Last date was
4th of August. I submitted the NIT, I participated it in terms of the amended MOA, which was submitted. Subsequently, I received certain emails seeking.
when did you submit?
I submitted on 4th itself. Only the tender document, not the MOA, because that's not a part of the tender document. That is our case.
You submitted tender on the last
Tender
date.
document with all the required documents that are required mentioned in the tender documents. We all complied, everything that they had asked for. So the requirement for the MOA was not there in the NIT. Subsequently, I received 2-3 queries in terms of an email from the department saying that we want to observe your MOA because your MOA does not have the object to perform the job as mentioned in the NIT. There were emails sent to us. Subsequently, I submitted my amended MOA with the Registrar of Companies because the requirement under the Companies Act is that once it is approved by a shareholder, which is a mandatory requirement for any MOA once altered or amended, to be submitted in the ROC, and ROC has to approve it. So the approval happened on 18th of 11/22, which is subsequent to the participation of the tender. However,
when was the approval?
18/11/22. I would, however, repeat for the sake of it that the requirement of MOA was not there to be submitted. Otherwise, the requirement mentioned in the NIT was all fulfilled by me, whatever was there. Number 2, the NIT that was introduced, your lordships, I had a technical support with me to participate in the NIT. This is an Iranian company who executed an MOA with me to participate in the MOA, in the tender,
so that the deficiency that I lack is substituted. That happened with an MOU, which is recognized by the NIT at page 76. That's the requirement in the NIT. It says that I can participate if there is a technical support or collaborator with me. So I submitted the MOU in terms of that tender document along with the tender document. Subsequently, after an examination on 12th of December, I received an email, which is at page 342 of my first writ petition. They had cancelled my NIT on the terms that I do not qualify because the object clause of the MOA, which was submitted subsequently for approval by the registrar of the companies, does not have the intent to do the job as mentioned in the NIT. And therefore, they disqualified me on a technical-commercial ground. This is in 12th of December 2022. Subsequently, I wrote a letter to the Oil India that was replied back by retiree to the fact that, no, since you do not have the basic criteria in the MOE, you don't stand a chance in qualifying this NIT. Though the qualifications that are required are all taken care by in the NIT. I have no problems for the technical as of now because the NIT still has not opened. Subsequent to that, in the same day, I had written a letter. Oil India is supposed to have an.
What about your technical support with the Iranian company?
Yes, that is existing.
Is it required that you put out as a single entity, independent entity?
Yes.
Is required to have that as one of the objects of the MOA?
Yes.
Or if with the technical collaboration, if you are in a position to perform the job, that will suffice.
Yes. The MOA that has been submitted, the MOU by which the support was taken, it was specifically mentioned that I have all the qualification that is required, terms of the company that is tied up with me. NIT does not say.
What is the requirement or necessity on the part of the department owner to ask or demand from you that in the MOA of the company independently should have one of the objectives of rigging?
Yes, I tell you why, Lordship. This has now been disclosed when the independent authority in which I submitted the representation.
That is the reason. But why is the reason?
Because there was a complaint filed. That is what has now been revealed by the order which I have challenged, which says that I do not have the authority.
You're on the objective part. Who filed the complaint? We are not bothered.
No, because that is how.
They have asked. The question will put to them.
Yes.
Why they have asked? If you can do the job.
Because of the complaint of one of the tenderers to the department. Yes.
Have the patience. We are not on why we are on the reason, the substance of the reason. Aren't they satisfied with your collaboration with the foreign company that the job in question, if you are selected, can be done by you with their collaboration? Why is the necessity of your company to have one of the objective to be in the MOA? If you are otherwise capable to do the job in collaboration with the foreign company.
Yes.
That is the question I must.
I just tell you, Lordships, when I apply the NIT, my qualifications in regards to the technical and financial are two aspects. I cover them the moment the technical support comes to me. So the tender approves that I can take a technical support. So the moment I take a technical support from the Iranian company who's working on an MOA basis to me, I qualify the tender. Now, whether in terms of all the people who participate, whether I stand good it will only happen when the NIT opens. But the requirement for the MOA was never there. That's my case. That the requirement for the MOA object clause was never a part of the tender condition. So therefore, my grievance is that could not have been asked by the department at the later stage.
Slightly different, digress. Why are you insisting that MOA of the company per se should have this objective? Because company is not doing the job by its own. It's taking technical support
If my friend,
as permitted by you.
I'll satisfy your lordship on that.
Because ultimately, we boil down to that aspect
That is
only.
yes. My lord,
Whether it has been done later or approval given by the ROC at later stage, whether those will come into those are the second
lordship.
issue will come at a later stage.
My lord,
But first,
then-
if we hold that without having a clause, there can be held qualified in the technical round
My
with
lord,
the collaboration of the
No,
Iranian company.
It's not that. It's not that. What has fallen from my friend is not correct. What I am on is that this company, with regard to the original MOU, its own MOA, does not have a clause, object clause therein pertaining to undertaking works of, my lord, oil and oil related It does not have that.
Yes.
Then what they did, my lord, it's a wrong statement that it was, maybe my friend was not in.
No, no,
instructed. Whatever it is,
we are
that
not-
MOA was submitted along with the tender. We saw it, my lord, during the process. There were complaints also, that's a different thing. We saw it and then we asked them that you don't have this clause or this object specified for the company. Now, my lord, there are decisions of the Supreme Court which says that a company can pursue only the objects that are there.
That you have shown.
That, my lord,
That
it's
is-
not there.
That is, no, now.
I'll satisfy your lordship on that. Now, the technical collaboration that he is talking about, that undertaking was done. There were actually, my lord, three. One is a Chinese company and the other one is that Iranian company, my lord. Now, I'll place, my lord, the Chinese company's thing. But there were three rigs.
Chinese for a company for the same work.
Same work, my lord, because there are three rigs. So he is getting one, he is buying.
Maybe
other-
Chinese is for the dinner purpose.
Now, my lord,
Collaboration only the
for dinner, my lord.
dinner.
My lord would have that and two dates, my lord. He says he has amended his MOA on 1/8/22. Now, from his documents, I can show, we had asked him on 3/11/22.
You're going to go to the second
No,
part.
no, no, I'm on that
Second
part.
part, we may
Okay,
agree with you, we may not
My lord,
agree.
we will have this, my lord.
Now, if suppose admitted in the original
He does not
memorandum
have-
of association,
He cannot
there
do
is
that.
no object of
Lordship.
doing rigging work.
Lordship,
But he has collaborated with a company which is permitted by the terms of the contract.
lordship.
Now he is in a position to do the work in
My lord,
collaboration.
will peruse that memorandum my lord, of understanding.
Which one? This one?
Yes, your lordship. His object was for consultation. My lord will see the third paragraph. This is on 6/7/22. Whereas
What is your
ACCP,
name? What is your name?
my lord,
ASC.
ASG, my lord.
ASC.
ASC Company Limited.
Hmm.
Whereas so-and-so is a company involved in oil and gas sector, providing drilling, workover and seismic services in India. My lord, this is on 6/7/22. He is making this statement. Whereas on that day, my lord, he does not have this object clause. So this very document, my lord, is not sustainable. And in the bid evaluation criteria 5.11,
6 July
22,
22, it was not approved.
it was not even taken. That resolution was not taken. Resolution was taken on 1/8/22. man. These are all afterthoughts.
Approved on 18/11.
18/11. Now I'll give you a date, my lord, further date. Now the requirement under 13 is, my
But
lord,
resolution was prior to, in any case, prior
Yes.
to submission.
my
of
lord,
the
that
tender.
is it. That is what I'm trying to tell before your lordship. Resolution, they say, is of 1/8, my lord. So the requirement is that you will have to submit it before the register of company.
That is the point we're trying to
My lord, it
explore.
was submitted on,
That is the point we're trying to explore. Let us assume a fact that he holds he doesn't take a resolution.
lordship.
Will he be disqualified?
Yes, your lordship, because that's not the object of his company, but he cannot participate. That's there, my lord. Decisions are there and even the act says so, my lord. You can't go beyond your object clause, my lord.
No, but if the company petitioner was participating on his
My
own.
lord, it's only a
on his-
qualified,
on his
no,
own,
it's
without-
only a qualified bidder who has that work in his object, who can go for, my lord. that.
If the petitioner was the bidder in his own capacity without any technical collaboration.
He would not have been, because, my lord, if he does not have that object clause, he cannot satisfy this condition. That rig he is taking from somebody, my lord, that much only. He's having that rig from somebody. It's only to that extent that these MOUs are there. If your lordship wants to see the technical collaboration criteria, my lord will have the condition, my lord, at page 63, my lord, 2.1.3 of the first petition, my lord. 526, my lord.
Yes. Page,
My lord, 63. It starts at page 62. I'll have my lord's attention. At page 63, 2.1.2, my lord. In case,
61 is bid evaluation.
the bid evaluation criteria,
Hmm.
BEC. My lord, I'll have my lord's attention at page 63,
61 is-
2.1.2, my lord.
Bid evaluation.
Lordship,
Criteria.
lordship.
Please. Yes, then 60, 62.
63, my lord, 2.1.2. In case
Yes.
In case bidder is an Indian company, joint Indian venture company, then the bid bidder should meet the experience criteria A to D in clause 2.1 above. Also, the Indian company, joint Indian venture who does not meet the minimum experience criteria as per 2.1.A to D above may also submit on the bid on the strength of a technical collaborator joint venture partner. However, the Indian Indian joint venture company must meet the financial criteria under so and so. Additionally, all the joint venture members will shall individually meet the financial criteria mentioned. This is not attracted in his case. Now, my lord, 2.1.3, my lord. Indian bidders quoting based on technical collaboration, it's a technical collaboration, shall submit a memorandum of understanding with the technical collaborator joint venture partner, clearly indicating their roles and responsibilities under the scope of work, which shall also be addressed to oil and remain valid during the binding during the contract period, including extension, if any.
Yes.
Now, my lord, on the date when they signed that MOU, it was beyond the scope of the company, my lord. Now we are concerned with ASC.
So this was signed on July 6th.
6. On that day,
Bid was submitted on 4th
4/8,
August.
and on that day, 6th July, that object clause did not have any oil-related work, my lord. My lord, we'll have that line, my lord, again. ASC, my lord, how they are
Where is your
projecting.
MOA?
I tell you, Lordship. Let me- let me-
You have a MOA?
Yes, I find it.
The MOA, my lord, I'll give the original MOA that they had submitted along with the bid, my lord.
I have filed it also in my writ. Both the writ petitions are available. The second writ petition, Your Lordship, the MOA is at page 126.
This is the MOA they submitted with the bid, my lord, section 18, page 29 of the bid. And it's there, I can show it, my lord, in the list of documents that they have annexed, it is, my lord, highlighted. Lordship, before my lord proceeds with the matter, just for my understanding, my lord, if your lordship can just take up the Companies Act.
Yes.
Section 4, my lord.
Where is your object? Which object?
Yes, page 126 of my writ petition.
Tell us the number.
The first is clause number 2 of the MOA, which has been submitted.
Carry on.
Yes, to carry on in India or elsewhere, business or patient, acting an advisor and consultant, all kinds of law, including matters relating to industrial, technical, civil, administrative, finance, expansion of industry, projection, purchase, and sales of material.
Projection.
Yes. Projection, purchase.
Not projection, but production.
In my lordships are reading clause number 2.
Yes, production is production.
That's my lord, I
Production,
think,
purchase and sales.
Yes, material, cost control, marketing,
Why is it
publicity.
projection in your copy?
It's,
my lord, it's the amended one which they are reading.
I'm reading the amended one.
Amended, how can production be projection? The
Clause
same
2 is
copy.
anyway not been amended, your lordships. Only,
No, no.
only the clause which is amended is
No, no,
clause
no,
10.
Not within,
In the writ petition, I'll give him a copy.
no, he can,
Yes,
my
yes, sir.
copy. There should not be any
Can't be any
discrepancy
different.
or
I agree with that.
understanding. Same, that page, it's
Production.
production. Clause 2. The page which I have opened for you.
Yeah, this is lordships clause 10, 12.
2.
This is different. This is not the one that I have. That clause 2.
Production.
Production is production. See, that is the two you are referring to.
This is here is projection, purchase and sales, your lordship.
How can it be different?
This is expansion, industry projection. This is what is in my paper book.
It's your document. These are only photocopies, not typed out.
And there is nothing here, my lord, pertaining to oil and gas. And that they amended subsequently. It was in my.
In my document, Your Lordship, it says projection. The
Is this
document
a
that I have
different-
filed. I
is-
agree with Your Lordship that it says
Is this a different document?
production.
Is this a different document?
This was in the bid, my lord. Section 18 of
This
the
is
bid.
what
Could not have been in the, there cannot be a
No.
difference of even a word, even a comma, because this is your document. Submitted with the bid.
In the other rate also, it's the same document that I filed, Lordship, it says projection. I'll have to verify this, but this is projection in my paper book.
This
But
is-
even
I can't improve on that. It says projection in
It
my.
doesn't matter, doesn't matter.
Yes.
There should not be major,
There should not have been.
major,
Yes.
this
I agree.
anomaly or
I'll have to-
difference. Then go ahead, purchase of sales.
Purchase and sales and cost controlling marketing, publicity, personal, handling of mergers and amalgamations, handling of public issues, assisting and setting up of joint ventures, foreign collaboration, foreign currency lending through ECB and other routes, and borrowing services of two non-residents. And the next clause that I was insisting is not at page 128 of my second writ petition, is clause 8.
Clause 8.
Yes, 128 of my second writ petition.
Here only we can. To negotiate.
Yes. No, this says to negotiate, to enter into agreements, contract with Indian and foreign individuals, company, corporation, and such other organizations for technical or any other assistance for carrying out all or any of the main objects of the company. So when I collaborate, I carry out their main objects for the company for the purpose of activity, research and development for manufacturing of projects on the basis of know-how or technical collaboration and necessary formulas and patronage for furthering the main object of the company. So the moment I do a collaboration, there the objections is only a furthering of the objections which are already existing. That is because, Your Lordship, when an MOA is created, it is created in the inception of a company. So the intent in there and subsequently in 10 years ahead of us, if we do get into a venture which is not
No,
exactly.
we may not disagree with Mr. Nair if he says that the original MOA did not have a clause connected with rigging. But the question which we are asking, if admitting that to be that submission of yours, there is no such clause.
Yes.
Empowering or having envisaging that they'll be engaged in rigging job. But the moment they collaborate before the bid is submitted, which you allow, and this foreign partner is
Having
the
required-
technical know-how of this kind of jobs, then what is the difficulty of
My
it?
lord, the difficulty here is that the company, if it was a company, my lord, having a object clause with, my lord, oil and technical rigging, he would have been eligible because a company cannot go beyond its scope of work. My lord will have section 4, my lord, of the
No,
company.
that we know, that we have also
That
you
much
referred
only,
to
my
the
lord.
Supreme Court case.
So Supreme Court,
But this company is not doing the work alone.
no, my lord, this technical collaborator here is not, my lord, anywhere related to us. We are only related to the company. It is he who says that this is my rig. I have this rig
So
with
you are
me.
along joint ventures.
No, my lord, it's not a joint venture also, my lord.
Technical support.
It's only a technical support
Collaboration.
and not a joint venture, my lord. It's not that these 3-4 companies have come together and a joint venture is being,
Yes,
no,
yes.
my lord. It's not that. The contract and all other necessary things would be signed with the company, my lord. And the company not having that object clause, it is, my lord, precluded. And that agreement, my lord, which has been, my lord, made, MOU, that is ultra virus.
How do you difference, what is the nicety of difference between a joint venture and having a technical
Joint
collaboration?
venture, my lord, both of them are together responsible, my lord. Then they will sign the contract, my lord. Together. Here, my lord, it's only the ASC which is before us. Then he says, I'll buy it from you,
Legal implication we understand.
lordship.
But
That's
for
what,
the,
my lord, we
but
are.
for the work to be done. with
My
a
lord, we
technical
say
support
because
which
you did not have it in terms of the Indian law that is holding the field, it's ultra virus, the Companies Act, as well as your MOA. And my lord would see when the agreement was signed, my lord. It was signed on 6/7.
If you take that stand, that's a different matter.
My lord,
That-
we'll have that. No, my
if
lord,
it's not
I'm
a- if it's
supported
not
by
If it's not a joint venture.
it's not a joint venture, my lord. My lord, I'm supported by a judgment.
You're only Mr. Fukan, not his partner.
No. My lord, there is a judgment of 1963 on this point, my lord. It's holding the field till wherein, my lord, it says one line, my lord. I just-
Where the judgment?
That's it. Where a company does an act which is ultra virus, no legal relationship or effect ensures therefore. So such an act is absolutely void and cannot be ratified even if all the shareholders agree. And my lord, this is, it will over connected. My lord, para 12 of that, my lord, 63.
No, you have placed this.
Lordship, that last day I placed it.
You
my
have
lord.
placed this.
So, my lord, if they
63.
can't have it in terms of their,
Let us see your bid, Mr. Fukan.
Yes. I would,
Bid.
yes, just one thing, your worships. The judgment that has been supported by my learned senior counsel, this is one aspect that would need to be considered, is whether I qualify the NIT. The entire basis of the BEC is whether I have the qualification to participate, because the requirement of an MOA is a subsequent to the tender process. On 4th of August, I submit my document. Till then, the requirement for an MOA has never arisen. It has only come subsequent. So therefore, my qualification to participate in the NIT is only through the eligibility criteria. If my eligibility criteria is suffices the document, whether with the top technical collaborator or a joint venture.
But
what
if,
bars me from performing the job?
but if it is not permitted by law,
It is.
can you preclude them from looking
No, it
into
is
this
because-
aspect?
No, it is because the NIT itself permits me to do that. The NIT itself says your
No, if the
eligibility
company law,
criteria is always
if
required
the
to be done.
company law says that objects which are not part of the memorandum of
In that terms,
association,
your lordship, then on 18 or 11, when the registrar of the company has given me a go ahead and approves my certificate, it's all, whatever the deficiency is all since rectified then. Because the NIT still to be finalized. So my deficiency qua on 4th of August now stands qualified.
no, on that you may not have a case. It's
No,
settled,
but
it's settled.
if at all they say that
It's settled.
existing-
Your,
No, but that will be,
your eligibility on all counts has to be on the, at least on the date of submission
but
of the
that's not a
tender.
requirement of the NIT. That's all I'm saying. If that was a requirement of an NIT, I would have not been standing before your lordship.
NIT is not required to say everything in every word that you have to a lawful object.
Your lordships.
Those are part of the statute.
I would have otherwise amended it. Had the requirement be there, all the other documents does not say that. There are a bunch of documents that I have submitted in
See,
that.
you are a company, you know your objects.
Right,
You know what is there in your memorandum of association.
yes,
And memorandum articles of association.
yes.
You don't have such a clause. Do you otherwise qualify to apply submit your bids?
If on the date of the hour, I do not have it. Now I have it. On 18th of 11, approved
Now
by the
the time
ROC.
is gone.
No, that was only when, because that was not a requirement to submit on 4th of August, your lordship. That's all I'm saying.
That
The
is gone.
requirement has not been spread out in the BEC, in the eligibility criteria. Had it they said that, no, you have to submit it by 4th of August, then I would have been out. But in that, the entire process is started after I submit the documentation. So therefore, they were still open for it. So on 11th of August, that stands, all the deficiency stands taken care of. And MOA, your lordships, with all due respect, is only the formation of a company. Obviously, as the company grows, there will be various reasons tomorrow where you would have gone into a joint venture, do a particular work. I may not have it. That is why.
That will not help.
No, but that would be in case
We'll
of a
have to
joint
go by
venture.
the
our lordships,
we
I
have
would have
to-
understood.
No, if you're expanding, you amend your clauses time
That's
to
what it
time, which you
says.
have not done.
That's what clause 12 says.
Have
That
you
I
done?
further into the MOA. Once
you
the moment
done?
Sorry.
Have you done the amendment?
Yes, the amendment was done.
After that,
Yes, but that the requirement was only after the submission of the last date of tender. It was not before that. The mail came to us only after that.
requirement is not requirement. What is the requirement? Requirement is that your MOA should have a clause which empowers your.
On the date of award, which is 1811 approved by
On
the
the date of
ROC.
award.
Yes. May I just read that clause once again, your lordship, which my learned senior counsel has just read,
Which
the
one?
BEC.
Page.
Yes. Take on page 63, your lordship. I'll read it once again. I might be able to convince your lordships. I read clause number 2.1.3 once again,
Of page,
of page 63 of my first rate petition, Your Lordship. This is 526 of 2003.
yes, sir.
Yes, I read that clause once again that my Lord City Council had read. Indian bidders, the last one, 2.1.3, quoting based on technical collaboration. Now, I am a technical collaborator, I am not a joint venture. Shall submit an MOU with the technical collaborator partner, clearly indicating their roles and responsibilities under the scope of work, which also is to be addressed by all and remain valid and binding throughout the contract period. So that's the only requirement. If I have that as a technical support, it is to be taken till the award is continuing. So either they say that the MOE itself is wrong because you do not have the criteria. Yes, I don't have the criteria. Therefore, the deficiency is taken care by a technical collaborator. I am supposed to sign the document, correct? Qualifications are both, not one. Because had it been my qualification, I would have never qualified in the NIT because I don't have that eligibility criteria.
Let us see the bid.
Yes, please.
Your bid.
I have filed the covering letter. The entire bid was not filed.
No, not required. We're covering letter.
Yes, 299. That's the first page. Memorandum of Understanding for Technical Collaboration signed with ASC Consulting Private Limited and Dana Petro Rig Kish Drilling Company, Iran. And at page 300, Your Lordships, the last paragraph, at page 300, I wrote a letter to Oil India, specifically saying that the criteria which they have is the last end, that Messrs. So-and-so, Iran is engaged in providing upstream services in wide spectrum, including field development, drilling, directional drilling, mud engineering, cementing, lodging, well stimulation, work, seismic, etc. Dana has more than 1 year of experience providing drilling services with minimum 1400 HP capacity rig on chartered hire basis, along with the manpower in a single contract, and drill more than 5 years numbers of gas wells with the drilling number of 1400 capacity in the last 7 years, out of which more than one well of the depth of 400 meters. As the original bid closing date, Dana is also having experience of operation maintenance of a top drive and rig during the last 7 years as an original date of bidding of the close. So that's the requirement that I am taking help of technical support. So therefore, it is absolutely correct that on that the MOE may not have that required criteria, but that's not the basis of an eligibility criteria. Had the eligibility criteria said, no, you have to submit an MOE, it said that your object clause has to define the work, then I would have been out. That is not the basis of it. And subsequently, the entire exercise, apparently we have come to know now that has been only started based on a complaint of some other bidder who says that the MOE is not sufficient. That only comes out in the report which has been filed by the authority, the independent agency, that there was a complaint. We do not know what the complaint is, where they have indicated this, and then based on that investigation, this report subsequently comes of rejecting my bid on the techno-commercial. It's not oil. Oil has only subsequently investigated a complaint. They never came up with this issue. So my eligibility criteria stands with the technical collaborator. That has not been disturbed till now. And if there is a deficiency existing in the MOA, if I agree to what my learned friend is saying, then it all stands rectified on 1811 because the NIT is yet to come into some kind of a form and shape. The agreement is not being signed. If I don't qualify, then in terms of the other tenders, that is fine. I have no problems in that. But would it be fair to say that because I don't have it?
As regards the qualification vis-a-vis a tender process, what is the law holding the field? What is the date of when you need to be qualified, a bidder, in all respects?
I have to qualify.
On the date when it will be awarded the contract?
Yes. So my qualification has to.
Or on the date when you would submit the bid?
Qualification as specified till the award.
Without qualification, you'll be awarded then ultimately by
they have to decide
on the contemplation, stipulation, speculation that on the date of the award will be qualified.
That is
not the law, I think.
With all due respect, that is what it says in the BEC.
That is not the law.
That is the eligibility criteria.
What is the settled law?
No.
In a competition, a bidder or anyone, a competitor, qualification, when what is the date, last date, that he needs to have all the qualification?
My submission is that that qualification is not required in the eligibility criteria. Whatever qualifications are
We'll
required, I have
consider, we'll
participated.
consider. Come to the next one.
Yes. Yes,
If you fail in the first, you have a second case
yes,
regarding participation.
yes, yes. The second rate, Your Lordship, 1061. There I'm aggrieved by the order which has been passed, Your Lordship. That is at page,
Would like to make your submission in a consulted manner.
page 158. Now, after
We
the
take up the second rate petition. then.
yes, the second rate petition, Your Lordship. This is 1061.
What is the stage? Was there any embargo by the court?
My lord had directed us to proceed with the work, open the tenders,
They
financial bids.
have been open?
No, my lord, but there was a further direction that his bid would be kept in seal cover.
Still covered.
Now, we are facing a technical problem, my lord. If we open it, if he is said to be qualified, everything will be open, my lord. It's online. And my lord, if we keep his bid aside, then my lord, we can't retrieve it subsequently. So, my lord, we have put it on a hold. And the work is, my lord, stalled, my lord, because of that.
You must be having some idea of the financial bids in the market. You definitely will be having.
I'm not aware. I'll have to take instruction on. I mean, yes, they said that they qualify, but just everything.
No, in the financial competition.
There are, I think, four or five.
You know
companies.
your bid. You know their bid also.
No, I haven't. I'll have to ask. I'm not aware of it.
Okay, second case.
Yes, yes.
What is the number?
Yes, this is
1061.
1061, yes. This is in regards to the independent external monitoring committee who has rejected my representation after the rejection of the techno-commercial bid. On the last occasion, your lordship had said that they have issued, that 7 to 11 would be issued notice. Lordship had said that you have to,
Some Bihuria was there.
yes,
Sutanu Bihuria.
yes.
What is his name? Bihuria or
Bihuria,
not Bihuria?
no,
Behuria.
Behuria.
Not Bihuria. Bihuria. Maybe it's Bihuria. Not this name, Sutanu.
Looks to be
Behuria.
Maybe he was Santanu. He could not spell his name properly.
Sutanu.
His
Maybe it was Santanu.
Santanu.
Sutanu doesn't make any sense.
Sutanu.
Urias they have, so to do.
Sutanu.
There are Urias and Bengalis,
Okay.
yes,
What did Mr. Sutanu try to do?
yes,
He's a member of Quipo.
yes,
Then Quipo
So-
is a competitor.
yes. He's one of my
And he's,
competitors who
he's also a
participated in
member
the
of
NI.
the IEM.
Yes,
He took a decision against you.
yes, which he was part of it till 1st of January 2023, when the letter was written to the organization invoking this at page 147. So the NIT which was introduced, your lordship, mentions a name and panel 3 names. These 3 names were existing from the time I participated. That's on 4th of August 2022, the date when I participated. So they were the people who were all looking after this agency. So when I filed the representation, Now I come to-
When was the NIT published?
yeah, it was 30th of June
36.
2022,
36.
30/6.
Oh,
Sorry, 3/6, I'm sorry, 3/6,
3rd of June.
3/6,
E-tender.
E-tender.
It named Sutanu.
Yes, it says Sutanu, Bihuria. It's also mentioned in the NIT,
I-
lordships, I'll just tell you,
I
it's at
am-
page 70,
I am 3 people, my lord. One of them is Sutanu Behuria.
Condensed
out of the
Sutanu.
3 people who participated.
I am condensed Sutanu. Did.
Yes,
When did Sutanu recuse?
we don't have the date, we only have the order
When
when it
did
says
Quipo submit its bid?
on the same day, 4th of August. So they will all prior to that, I don't know, the last date was 4th, but I don't know when they have participated, when they have finally submitted it,
Last day 4,
4 August,
22.
yes.
Last date. Sutanu was the director of Quipo.
Yes. If your lordship sees page 70, the names are mentioned in the NIT. in the,
People participated.
yes. Page 70 of this writ petition.
Mr. Nair,
Lots of-
even before this case, there is no such case like this, let us assume. But is it fair to have somebody in the, somebody to take a decision in case a dispute arises by a person who himself is a competitor?
Lordship. My lord, this
Won't that give an impression to the
Lordship,
public in general?
I completely agree with my lord. But this,
At least, at least when
no, no, I'm
Kuipo had
participated.
submitted his bid on before, on or
Lordship.
before fourth, he
Lordship,
should have recused.
my lord,
That whether there is a bid contest or not, I will not be a part of IEM because my company is one of the bidders.
Lordship. One, my lord, this IEM is not constituted by us, man. It's an independent body by the Central Vigilance Commission. Central Vigilance Commission has their own
It's not
guidelines.
your committee.
No, my lord, it's a committee constituted by for all organizations wherein, my lord, tenders of a particular value is done. Then, my lord, an IEM is considered under 25(1)(22), my lord. There's a circular.
They who nominate for
And it's called an integrity pact, my lord. Then they give us.
This Sutano's name was existing even prior to
Yes,
the 3/6/2022.
yes, my lord. He's there from a period before that, my lord.
Where?
My lord, that exactly he would be, my lord, Sutano 20, my lord. Page 12 of that, my lord.
The page 12 is your NIT.
No, my lord, of that document compilation. which
Yes,
I've-
yes. You have
My lord.
written 3/6. This is 3/6.
3/6, my lord would see, interpret a second name down below,
Yes.
Sutano Behuria, 18/3/2020. And he was there up to, my lord, 17/3/2020. And the approval reference of the CVC, 27/2/2020. They are appointed for 3 years, my lord.
by the city.
And that procedure itself, my lord, contemplates page 7, 4.9, my lord. We have nothing, my lord. This body is there. We also can go to the
At present, oil is having a panel of 3 IEMs
lordship.
as approved by the CVC.
Lordship.
And out of those 3, Sutano Behuria is one of those.
Lordship.
Them. Now,
Then, my lord, the one of them, Rudra Gangadharan, his term expired on 25/8/22. Next page, my lord, would
I
find.
understood, 25/8 was after the date of the tender.
Tender. And my lord, then they nominated at page 14, 11/7/22, Mr. Bhashim. My lord would find page 14 and 15. Biodata, so and so TM Bhashim,
We, whatever you say, we accept.
lordship,
This is a panel prepared by the CVC,
lordship,
which as a part of the integrity pact,
lordship,
you have them in your panel.
panel. In
Now,
that
he
panel,
was a person who was already appointed in the year 2020.
lordship,
Now you have him in the panel to also be members of the IEM for this contract.
my lord, that
For this
IEM is
contract.
for all contracts. We have, my lord. It's a panel, one panel, my lord, for all contracts.
No, but this,
And the, my lord, the interest clause, if there is an interest generating, my lord will,
coincidentally or incidentally.
lordship, that my lord will
The
find
date
in
is the
page,
same, date
page
is the
7,
same,
my lord.
3/6.
page 7, my lord.
No, date is the same, 3/6.
Lordship,
When you wrote to the secretary vigilance,
lordship,
this indicates that it's only for this contract you have started this 3/6. Contract is also 3/6.
no, my
NIT.
lord, this is, my lord, because we had to write, because Rudra Gangadharan, my lord, his term was expiring on 25/8. It's a general letter written, it's not for the contract, my lord. My lord will have it at page 13.
Peter is giving all the benefit of doubts to you.
No, my lord will have page
No, no,
7.
you wrote this because one of the person
Was retiring, my lord, so we
He
can't
needed to be
appoint.
Substituted.
We can't appoint.
Now, now Tutano Bihoria knew that he is a member of the IEM for even for oil.
Lordship,
And his company has submitted its bid on 4/8/2020.
lordship.
Did he take any step prior to 4/8
My lord,
to stay away from the IEM?
the issue came up when, my lord, they raised a query. Otherwise, the IAM is not even bothered, my lord. It's not even concerned. When they raised a query, he recused himself. He has not examined that query. He has not deliberated upon that query. Now, how can I prove that?
Tell us, you can just.
I can prove this one.
No, how, when does the role of the IEM comes in?
Role of the IAM comes in, my lord, when there is a dispute raised and that dispute is considered. Because it's a mediatory body, my lord. There can be a mediation there. Or, my lord, they can adjust between us and give us a non-binding recommendation.
Only when there's a dispute.
Dispute, my lord. And, my lord, on 9th, when the body sat, they and we were heard. My lord, Santanu Bihoria was not a part of that deliberation. 1. 2, my lord, on 9th, the proceeding was not completed. They were given time to file additional, we were also given time to file additional written arguments. On 10th, my lord, these written arguments were filed. If this was the point, my lord, that Bihoria there should not have been a part of the deliberations, they should have raised it on 10th. Why I am saying so, if my lord takes up the writ petition for a moment, my lord. My lord will come to para 18.
How do you overcome Kripak? Even Kripak has
My lord,
recused.
I'm coming to that, my lord. My lord will have page 8. He never considered, my lord. That's my
Even he
case.
had recused from the selection.
My lord, he
committee.
never considered. My lord, it would be like this, my lord. A writ petition is filed. My lord, my due
Have you
apology.
got Kripak, Mr. Fukan?
Yes.
My lord, if I may just make one submission, my lord. There is a writ petition filed. Say, my lord, before this honorable court. One of the honorable judges cannot take it up the matter. My lord, moment the writ petition is filed, the judge would not be in a position to recuse. He would be in a position to recuse when the matter comes up before the honorable judge. On that day he recuses, he will not hear the matter.
The writ petition may come before this, or may not come before.
May
this, because
not come.
There are many other benches.
Many other
But
benches.
unfortunately, there is only one bench in your case.
What I'm telling, my
If
lord,
it comes, it will come in your bench only.
my lord will have page 25, para 18, my lord. I think that will satisfy your lordship.
Of which writ petition?
Of the second writ petition.
Page?
Page 25, para 18.
25, right. Yes, please.
That the petitioner begged to state that they came to know on 9/2, my lord. My lord has got the date. That Sri Santanu Behar, respondent number 7, who is one of the member of the IM, has a conflict of interest as he is engaged with one of the bidders during the tendering issue. He withdrew during the IM meeting, informing all the participants about his association with one of the company having interest in his tender. On coming to know of such fact, the petitioner inquired about the same and came to know that respondent number 7 is a director of KIPCO Oil and Gas Infrastructure Limited. Hence, so-and-so could not have been being a member of so-and-so bid closing date the day oil came to know about the parties having submitted bids. So this is the case. Now, my lord will come back to my compilation, my lord. The last, page 16 there. So on 9th, he knew about it. This, my lord, he made it on 10th. Page 16, my lord, document. He made this on 10th, my lord. 10/2/23, my lord has got it. Top. Here, my lord will not even find a whisper of that allegation, my lord. So he submitted to that, my lord, because that man was not there. And the finding of the IEM, my lord would find.
The man was there. He has marked.
No, my lord, the man was not there. That's his statement.
Number one.
No, that's his statement, my lord. That is his document. He's sending it still. My lord, it's his document. He's sending it still. My lord will have page 150 at the minutes, my lord.
Annexure 4, document 4 is his letter.
His letter, my lord.
And this is dated? 10
Dated 10. On 9th, he knew. But still, my lord, no objection. He has already recused, my lord. This is just, he has made it.
What is the statement? He withdrew.
My lord, 158,
No, at 25, page 25,
lordship.
paragraph 18, Evermans.
He withdrew on 9th, my lord.
No, he withdrew during the IEM meeting. When
No,
was
my
the
lord, would
meeting?
say page 158, my lord, the IAM minutes,
158,
158 of the writ petition, my lord.
yes,
So Santanu Boria recused from the deliberations,
9-2.
9-2, due to conflict of interest as the honorable IAM is engaged with one of the bidders in the instant tender. He said and he withdrew. He didn't never participated. And lordship would come to that portion at page 162. So after hearing, my lord, the parties, the IEM consisting of Bhasin and Singh, my lord, page 162. My lord would see, after hearing the representation 5, my lord, clause 5, after hearing the representation of the complainant, so and so, oil response to the same and subsequent deliberation on the subject matter in the hearing meeting held on 9/2/2023, IAM advised both parties to submit written submissions to substantiate their presentation as well as to answer each other's argument in concise and clear points so that the IAM can come at a definite conclusion. Basing on this, my lord, this document at serial number 4, page 16 of my compilation was submitted. And therein, my lord, will find, that is, my lord, these are all developments made subsequently, my lord. Therein, my lord, will not find even a whisper. My lord, he had already recused. There was no point in their taking up that point. Now, for the purpose of making out a case before this honorable court, para 18 has been demonstrated, but therein also, my lord, 9-2 they knew. They could have very well written that this IEM is not proper. We will not proceed with this IEM. And he, my lord, he was not recused. He had not recused because some party had pointed out. He on his own had recused, my lord. He withdrew during IEM meeting. Meeting. And my lord, for the purpose of this case, my lord, if I may make one submission. I say 6.9. Page 7.
Your contention is that IEM is already an existing body, Syncra panel,
by CVC.
which by CVC, you had entered into an integrity pact with this IEM.
No. We have entered into integrity pact with the bidder. Bidder and the, my lord, the oil enter into an integrity pact.
With naming this IEM.
By naming these IEM.
And the function of the IEM will come only when a dispute will
Arise.
And the moment the dispute came, he recused.
My lord, would come to page 69.
Otherwise, his role, there would have been no role.
In this matter. And my lord, there were no documents before him so that he can influence that. Just the representation of the petitioner was sent in its mail. We send our response. It was during the hearing on 9/2 that the issues were come out, my lord. Called out. And lordship would try to have the role of the IEM, page 69, my lord.
Yes.
In the page 61, 31.3, my lord. 31.1, oil shall be entering into an integrity pact with the bidders as per format enclosed in proforma M of the bid document. My lord has got it. Then, my lord, in case of a joint venture, all partners of the joint venture should sign the integrity pact. Now, my lord, 31.3. In the event of any dispute between the management and the contractor relating to those contracts where integrity pact is available, in case both the parties are agreeable, they may try to settle the dispute through mediation before a panel of independent external monitors in a time-bound manner. If required, the organization may adopt any mediation rule for the purpose. In case the dispute remains unresolved, even after mediation by the panel, the organization may take further action as per terms and conditions of the contract. Now, page 98. 97, my lord, it starts section 8. It's a part of that integrity pact. Pro forma M, it starts at page 94. 98. My lord, here I will have trouble, my lord, with page 98. 9.
97 it starts, isn't
Oh,
it?
no, my lord, it starts at 94, my lord. Integrity
No, no,
Pact
no.
94, clause 8 starts at page 97.
Section 8.
Section 8, my lord. My lord, we'll have at page 98, clause 5.
Yes,
5, my lord.
98, 5.
5. As soon as the monitor notices or believes to notice a violation of this agreement, he shall inform the management of the principal and request the management to discontinue or deal the violation or take other relevant action. Now, this is important. The monitor can in this regard submit non-binding recommendations. Beyond this, the monitor has no right to demand from the parties that they act in a specific manner, refrain from action or tolerate action. However, the independent or external monitor shall give an opportunity to the bidder contractor to present its case before making its recommendation to the principal. Now, my lord, 9. In case of any complaints referred under IP program, the role of IEM is advisory and would not be legally binding, and it's restricted to resolving the issues raised by the intending bidder regarding any aspect of the tender, which allegedly restricts competition or bias towards the bidder.
Advisory.
Advisory. Now, my lord.
Non-binding.
Now, my lord, I understand what is troubling your lordship, that there is a body should be seen to be thing also. Now, my lord, what is the issue raised here? The issue raised here by the party was that, see, the question that is being raised by the company, that I did not have this object clause in my memorandum of association. So because of that, I have been rejected. Now the IEM, my lord, would come, I'm troubling my lord at page 162, my lord, the final conclusion.
162.
162, my lord. Final conclusion of the IEM. As advised by the Honorable IEMs, further submission by OIL and MSAC were provided accordingly. The IEMs carefully considered all the documents and arguments presented by both sides, and I have also gone through the section 13.9 and 13.10 of the Companies Act, which specifically mention no alteration made under this section shall have effect until it is been registered in accordance with the provisions of this section. The IEMs concluded as under. The amendment addition in the object of so and so as per section 13 would take effect from 18/11/22. Since as on bid closing date 4/8/2022, the MOA was not having the desired clause, MS so and so would not have been qualified to be a tenderer for the said activities and thus technically incompetent to submit their tenders. Hence, there is no merit in the reference made by so and so in the caption matter. So, my lord, the conclusion that the IEM has been reached by the two members is in connoissance with the decisions of the Supreme Court and the Companies Act, my lord. And that is what, my lord, is testing in the first writ petition. Now, my lord, one more fact, my lord, which requires to be placed before my lord. My lord, the last date of the tender submission was 4/8. Admittedly, on the date 4/8, when they submitted their bids, my lord, there is a requirement in the tender, section 18. If my lord can, I can place that, my lord, before your lordship. So lordship can come to page 110, the index of the document submitted by my friend, client. My lord, the W101061, my lord. If my lord wants the other one also, it's there. Which one is open before your lordship?
We are having the next one.
Then my lord, 1061.
Yes.
Then my lord, 110. Or 109, my lord.
109.
109. This is the techno-commercial bid submitted by the petitioner. 110 is the index. And my lord would find
100, yes. But
here each section is been given, and against that section, my lord, documents that are required are being submitted. Now, my lord may come to 113, my lord. Section 18. My lord has got section 18, memorandum and articles of association of the company. And I have placed before my lord, in that it was not there. Be that as it may. Now, on 1/4/2018, my lord, of 1/8/2022, my lord, it is said 1/8/2022.
Just a minute. Yes.
Now, my lord, as per their contention, on 1/8/2022, in a special meeting, this was amended. This clause was amended, and my lord, the provision for undertaking work in oil and oil related activities were brought in the object. Now, on 4/8/2022,
1/8/2022.
the special resolution of the shareholders was taken, my lord, wherein, my lord, the criteria for undertaking the object of the company was amended, and oil related activities was included.
It was amended.
Amended. On 1/8/22, a special resolution was filed. As per their statement, my lord. On 4/8/2022, when they filed the MOA, this was not brought on record. This amendment was not brought on record.
Because it was not approved by the.
Right, my lord, right. I'm with my lord. On 3/11, my lord, if I may just give my date, the mails that we started to make for them, my lord. I'll just give that date, my lord. Yes, 3/11/2022, my lord. That, my lord, will find in the other case. Just, my lord, may make a note. 325 page number, the second, that first writ petition. We asked them to submit the MOA filed before the Register of Companies positively by 7/11/2022.
Okay, 3/11, you had asked.
I had asked, my lord, 325, 3/11/2022, email we had sent. Then, my lord, then they reply on 7/11/2022. Wherein, my lord, they, page 328, my lord. Page number 328 of WPC, the first WPC, my lord. 526.
Yes, what happened to
They, my lord, submit a copy of the memorandum of association of the company and, my lord, amendment to the MOA dated 1/8/2022 of the company. 3/11, my lord.
This is on?
This is on 7/11/2022. Then, my lord, now, my lord, the registrar's approval comes on, my lord, 18/11. 18/11/2022, the registrar's approval comes. Now, the requirement under the law is, my lord, that the registrar, within 30 days of submission of this before him, he has to approve. The provision of the law, 13, my lord, says, they forwarded this to the registrar basing on their own documents on 4/11/2020. That they cannot deny, because, my lord, page 355, it is clearly written. No, 120. 22. My lord, this document is also there. There is a statement in the earlier case that this was sent on 4/11 and the document is also there. It was forwarded to the registrar only on 4/11/22. So my lord, that taking of that resolution on 1/8, my lord, becomes doubtful. And even if my lord holds that they had taken that clause on 1/8/2022, that agreements that have been entered into with those companies prior to that date, my lord, in terms of that AI 1963, is violating ultra vires the provisions of the object, my lord. In this view of the matter, my lord, the petitioner cannot be said to be a responsive bidder. Even, my lord, why responsive bidder? He is not entitled to bid, my lord. Today onwards, after that 1811, my lord, any tender comes in, he will be eligible, my lord. He'll be eligible. It's not that he'll not now for all times to come, he'll not be eligible. And my lord, any false information submitted, the bid evaluation criteria 5.11 clearly provides, my lord, it is to be rejected. Is it 82 of the, my lord, second writ petition. Page 82 of the second writ petition, my lord, 5 point, it's there also in the first one. Any bid containing false statement will be rejected. And my lord, this plea now that has been taken, that this MOA was never submitted. It's false one. Their own index of documents, I'm showing, my lord. Section 18, page 28, this was one of the documents. And there was no such condition. And in that view of the matter, my lord, in view of the provisions of 13, my lord, if lordship can have 13. Companies Act, my lord. My lord will have 13(9), my lord.
Involved in
13(9), my lord. (13)(9), the registrar shall register any alteration of the memorandum with respect to the objects of the company and certify the registration within a period of 30 days from the date of filing of the special resolution in accordance with clause A of section 6. And my lord, 10, my lord, has already read, or no alteration made under this section shall have any effect until it has been registered in accordance with the provisions of the section. So that resolution of 1A, which was only forwarded on 4/11, will come into force, my lord, from 18/11/2022. And now,
Firstly, there is a conflict involved in oil and gas.
and my lord, section 10 also, my lord, says that the company is bound only to the extent of its memorandum, and they must observe those provisions. And lordship would see the wrong projection that I will not say, my lord, anything else, a wrong projection made while entering into a memorandum understanding with that Chinese firm, which is a part of that bid document. They projected themselves that they are involved in oil and gas sector. Wherein, my lord, till on 6/7, the memorandum of association never even contemplated that. It came into being, even if I go by their words, on 1/8 only. Whereas ASSPL is a company involved in oil and gas sector, providing drilling, workover, and seismic services in India. It's unknown, man. It's ultra vires, the provisions of that day, my lord. My lord, in that view of the matter, my lord, these are rigs, my lord, which we have. The work involved, my lord, is of immense importance. And my lord,
What is the value of the work?
value would be, my lord, it's a lot of work. Now, no? Four rigs, my lord. So, my lord,
This is for one rig, isn't it?
no, my lord, all different, all different. That's why, my lord, different parties they have given, my lord. I'm just giving the value, my lord. The value to ladies. Value to give, my lord. Yes, what the hell is it? What the hell is it?
What are you looking at?
No, the value, my lord. Just fine, figure fine. I've seen it, some indication was there, my lord.
Page
Could you answer?
78. Page 78 of this.
Second one. Second one.
No, that's the financial evaluation.
Financial evaluation.
I'm
no,
sorry,
no,
that
no,
is the financial evaluation. Can I just take your lordship to page 70 first?
70?
70.
70.
Yes, of this writ petition, 1061. Clause 331.4. The bidders may contact the independent external monitors for any matters relating to the IP at the following addresses. But the three names are mentioned here. The first name is Mr. Sutonu Bihoria. Second name is Rudra Gangadhar. And the third name is Om Prakash Singh. So the time when the NIT was floated, these are the three people who have been picked from the list of people approved by CVC and approved by the company, which is Oil India, to decide the agency who will decide the any grievance. None of this in any of the papers laid down before your lordship say, when did Mr. Bihoria actually recuse himself? The allegation is that he has been a part of the deliberation. It is not necessarily whether I'm there or not. It could be a factor that the gentleman available on that particular could have been influenced without being there. The case is not mine that the gentleman should have been there or not. The question is whether he could have influenced the deliberation that took place. And with all due respect, the deliberation starts from the day I start participating in the NIT, knowing well that yes, one of my companies and where I am a part is also a bidder in an as important NIT as this. So the question of whether I am being put into a fair trial or not will only be decided, not in basis of a recusal that happens on a particular day, but in course of the entire deliberation.
Whether you have been treated fairly.
Yes. Now, there's not a single document to say when we filed a letter on 5/1 that we want to invoke this agency, the letter was marked to Mr. Bihoria. Never they were informed to us that no, this gentleman is not available anymore. Could be subsequent on 9/2. That's the second leg of an argument. Whether the gentleman was available when I invoked it, he was available. That letter was marked and I have annexed it in my writ petition also, duly replied by Oil India, or for whatever reasons, that this gentleman was available. If he was not available and had requested, he should have intimated us. Subsequently, it's also been informed to us that the other gentleman is also not available. There's not even a single deliberation, not even a single letter on an email to us saying that this gentleman is no more available and that somebody else have been
But what about the minutes of meeting on 9th?
I'll come to that. I'll come to that.
You
I'm
were
talking-
there.
I'm talking about what started initial conception. What happens is subsequent to the closure of the NIT. That is the second phase of that. My fairness could have to be looked into the time when I participated in the NIT. That's my grievance. My grievance is not subsequent. Subsequent, there could have been a lot of other things being done by me as well as by him. But does it preclude me from that fairness? Is only thing that needs to be seen is the deliberation. I could have influenced him before also, when he knew that I had participated. Number one. Number two, they have been saying that Oil India has no role to play. This is appointed by CVC, no role to play. Would your lordships come to page 97?
Yes.
My learned friend read 98, 97, section 8 of the external independent monitors/monitors. Number one,
97.
97, your lordship. Number one, the principal appoints the competent and credible external independent monitor. It's not CVC, it's the principal. So the principal is who appoints the independent monitor for this pact. Is the same integrity pact that I have signed. The task of monitor is to review the independently and objectively whether to and to what extent party can comply with the obligation under this agreement. So it is the principal who appoints. CVC gives you guidelines. CVC gives you members available on the board. We can pick. Why was he picked? There were other members available. You could have done it. My part starts only after 5th of January 2023. These are all deliberations which have happened after. I am aggrieved because from the initial inception of that, there is no fair trial. Had it been fair trial, this situation have not arisen because it was all under your control. Now, your lordships, I'll take your lordship to the letter that I have written. (26) 139. The date is 26th of 12/22. December 2022, much subsequent to the rejection of my NIT. This is addressed to the general manager contracts.
Yes, sir.
Request Oil India to intimate status of our offer of the prize bidding opening. Rejections to provide us a fair chance to represent to our case in IEM with the provisions of the tender in terms and conditions. Now, number two, meanwhile, we have taken an external opinion in the matter of Oil India Limited, considering the bid submission of the AAC Limited, the bid opening in issues of subject clause of the MOA. The external opening has been taken to be by a renowned so-and-so. Para 4. In case oil still having reservations to the considered price beginning of ASC Consultant Limited should immediately inform us to remove further with legal and other remedy with the provisions of the tender conditions. Now, would your lordships come to page 140? The letter has been marked to Sutonu Bihoria, respondent number 7, Rudrak Gangadhar, respondent number 8, and Om Prakash Singh, respondent number 9. Till I am not intimated. None of them intimates to me that I am not available. Somebody has resigned or not available because of his incapacity. Next. Page 147. Another letter written. All subsequent.
My lord, the value is 634 crores.
6.34.
634 crores.
634.
34. And there is little bit, my lord, I'm approximately, I'm saying.
3 rigs.
4.
4 rigs.
4 rigs.
$147. The letter is 5th of January 2023, just before the report has come. $147, same repetition.
M.
Yes. Yes. Last time they were marked in the previous letter. I again email it to them. I again write to them. 5th of January 23, marked to Oil India also. and subsequently on 19th of January 23 at the next page 149,
2020.
23.
But recusal was a 9-2.
9-2.
9-2.
That was the date when the deliberation took.
The deliberation, date of the deliberation. So mine is all subsequent. With all due respect, the deliberation starts from 5th of January. Because I wrote a letter. They haven't intimated to me whether he's available or not available. I do not know about it. If it's a fair trial, I should have been intimated immediately that no, this gentleman is not available and he's recused. So there'll be somebody else who will be deciding the independent authority. No, there's nothing. And on 26/12, the same, I write another letter, which is prior to this. They still don't intimate to me. And on 19/1/23 at page 149,
149.
19th of January 2023, page 149. The reference says of the letter dated 5/1/23. That's the letter that I wrote to Sutano Behoria and the Independent Monitoring Agency, but it's been replied by them, rejecting my claim, saying that no, you don't stand a chance because your MOA was not sufficient, the object clause. It is subsequent to that the order was passed, Lordships, at page 158. I'd like to read that once again with the Lordship's permission. That's the minutes of the meeting.
Minutes.
Yes, the minutes of the meeting at page 158.
Yes.
So till then, he was part of the deliberation. And he says, Mr. Sutano Biharu recused from the deliberation due to the conflict of interest as the Honorable IEM is engaged in one of the bidders of the institute. After all the two letters, where is the situation of being recused? You resign. If not, at least intimate to me. Nothing. So the deliberation continues in spite of the fact that I have written two letters to say that I invoke this agency in regards to the same query. Where is the question of a fair trial? I would go one step ahead to say if it is a situation where he resigns, could he still not have influenced the committee when he knew? And at page 159, 159, the next page. It's the third paragraph, Your Lordship, where it says, complaint was received from one of the participating bidders against a tender alleging ASC is violating the doctrine of ultra-virus due to non-compliance of an object clause in the memorandum of association as per the Companies Act. The bidder stated that ASC is legally not allowed and capable to bid for the tender services and not listed in any of the activity remotely linked petroleum exploration and so and so. So the entire exercise, the Lordships had asked, why did it start? When did it start? It started on a complaint. We do not know what the complaint is because we do not have a copy of the complaint. And nobody has produced this complaint also. So if one of the tenderers, who is a competitor of mine, files a complaint, would it be still fair enough for the gentleman to sit?
Yeah.
But this is not signed by him. Unfortunately, signatures appear at 162. And we go by objective test.
I'm still on the deliberation. The outcome is on 19th, where he says that I have not signed. The report is one situation.
The minute starts with the first
Yes,
line.
on
That he
9-2.
has recused.
On 9-2. That's the deliberation. We do not know when he is recused. He says 9-2.
Assuming if 9-2 also, he recused at the starting of the meeting.
But he was a part of the deliberation from 4th of August. From 4th of August, the process starts. He knew I have participated. So if he's a part of a deliberation, there's every chance that he could influence. This has happened much later. My rejection is in December. I could have understood when I had gone into
No, the
dispute.
role, what Mr. Nair is trying to highlight, the role of the members of the IAM would start the moment a dispute arises.
Correct, which is December 12th.
Now-
December 12th, 22.
December 12, when did the IAM first meet to
The
deliberate?
rejection of mine.
Yes,
For the technical motion.
9-2.
Right. I write to them on 26th of December,
9-2, when they first met, because they gives you one month period
23.
for resolution of the dispute.
That is 23. I'm on 22.
And on 9-2, they said, and he recused.
That is the next year. I'm talking about 22. I was rejected in December.
Now,
I write a letter to
was there
them.
any decision taken in between?
Sorry.
Was there any decision taken in between?
Yes, madam. There is this one. 5-1 is the first letter given. That's the complaint, madam. 5-1, 2023. The IEM on 3/2/23 wrote to them, fixing 6/2/23 as the first date of meeting. They approached the IEM and said that we want some more time. That is how it was fixed on 9/2. That, my lord, would find at page 158, second paragraph.
No problem. I would still go back to 139, which is my first letter of.
The hearing
26.
meeting.
Hearing meeting, my lord, we'll have the first paragraph. The first paragraph is recused, and then, my lord, a 3/2. The hearing meeting was scheduled on 6/3. My lord will have, the hearing meeting was scheduled on 6/2/2023 with an intimation of the meeting to the complainant on 3/2/23. And they don't say that this intimation was given by Behuria. Never have they said that. Because he had already recused.
Okay.
Now, my learned friend had also pointed out in regards to the document of the MOA that is required that had filed in regards to the chart,
Which one?
the MOA, which is page 109. That's the techno-commercial bit along with an index that I submitted. He has impressed upon your lordship that at
Section
page
18,
109 it starts, yes.
113.
Yes, at
Section
113,
18.
he said memorandum of article of association of the company. Now, the documents that are required is at page 58, which is the BEC. Bid evaluation criteria.
Yes.
At page 58.2.1 are all the documents that I'm required to submit at the time of submission of the NIT. There's not even a whisper of an MOA. This MOA that was submitted was submitted subsequently.
That uploading, it's uploaded in one go, not in separate bits.
It is not a part of the NIT. That's all I'm trying to say. It is not part of the eligibility criteria.
But you had given.
Given it.
Yes.
Section 18, it is
Not
required. madam.
subsequent.
When it is not even a part of the NIT. That's all I'm trying to say, your lordships.
What he has submitted. Submitted.
It is, they have asked, the amendment to the MOA was on 1st.
Well, occupancy the date 4/8.
Exactly. It was on 4th of August. The documents do not say that I need to submit that MOA. That's all I'm trying to point out. This is only an index that I have submitted. The qualification does not say that the MOA needs to be submitted or the documents that is required to be submitted.
We have noted your
So
point.
yeah, that's what.
Your point. You said that when it was not even a document which was required,
Yes,
they cannot take advantage of the document
Yes.
to be first register. It
yes,
considered.
yes. And your lordships had asked about this judgment. Paragraph 15.
Which one?
Kripak. Your lordships is on the last occasion has referred. There's only one paragraph that I'd like to read, your lordships. At paragraph 15, it says it's unfortunate that so-and-so was appointed as one of the members of the selection board. It is true that an ordinary or chief conservator of forest in a state should not be considered the most appropriate person in the selection board. He must be expected to know the office throughout and his weakness as well as his strength. His opinion in regards to the suitability for a selection of an all India service is entitled to a great weight. But under the circumstances, it was improper to have included him as a member of the selection board. He is one of the persons to be considered in the selection. It is against all canons of justice to make a man of his own cause. It is true that he did not participate in the deliberation when the committee.
Exactly, this is the point.
Yes, in his name of the, it was considered. But then the very fact that he was a member of the selection board must have its own impact on the decision of the selection board. This is where I come from. It is not whether the deliberation starts on that. I say the day I participate in the NIT, that test will start. I'll pass it to the lordships if you want.
Anything to comment on Kripak?
Lordship. My lord, Kripak will not be applicable here. Why I say so, my lord? Because this is not a body. My friend has said that, my lord, we appoint, principal appoints. It's not that, my lord, I have given the bunch, my lord, this bunch, circulation.
Yes.
Therein, my lord would find how the appointments are made. My lord would come to page 9, my lord.
AK Kraipa, what is the
Citation
citation?
required, AK Kraipa.
Citation.
It's 1969 to SCC 262.
1969 2 SSC 262, para 15, my lord.
Yes.
My lord, here, my lord, Nashiband, who was included, he should not have been there. It should have been the chief conservator of forest, but he was. But here it's not that, my lord. This para page 9, para 5.4, who would be the, my lord, IEM is determined by the commission. They send the names to us and we only have to nominate them, my lord. We have to publish their names. The commission,
Page 9.
page 9, 5.4. The commission would nominate
Commission is the CVC.
CVC, my lord. The CVC circular. And this is done by CVC, my lord, not by us. For an organization. Accordingly, my lord would see, it's not that for this contract, Sutanu Behuria was brought in. Sutanu Behuria is there from 2020, my lord, all along, and he is now no longer there. 17/3, 2023, my lord, he is gone. 3 years is the time, my lord. And even my lord would find when a person expires or retires, when their age of 3 years is completed, we have to write to the CVC. And then, my lord, CVC will nominate. And accordingly, Bhasin had come in. And my lord, I had an occasion to appear, I think, my lord, during the last 2 to 3 years, or during COVID, just after the COVID, the Oil India matters, either, my lord, from that side. My lord, Sutanu Behuria was one of the, in all, and even that matter is in appeal, Sutanu Behuria is there, my lord. So, my lord, it's not that Sutanu Behuria had been there for his period. Now, my lord would see how my lord would come to page 158. Once, my lord, for my satisfaction, my lord.
Yeah, minutes.
Minutes, my lord.
Yes, please.
My lord, 2, he recused from deliberations. So deliberations, my lord, were to be held on 6/2/23, my lord. He was not a part of that. The hearing meeting was, 2, my lord, the hearing meeting was scheduled initially on 6/2/2023 with an intimation of the meeting to the complainant on 3/2/23. However, due to paucity of time to represent, the complainant requested the respected IAMs to allow them some time extension so that they can prepare for the said hearing meeting. After due deliberation, IAM considered their request of extension and rescheduled the meeting on 9/2/2023. So, my lord, he is not there, even, my lord, in the initiation when the deliberations had not even begun, my lord. Sutanu Behuria had before that only recused. Now, my lord would come.
Is that the meaning?
Yes, your lordship, because here my lord would find from the deliberations.
Read the first and the second.
Lordship,
paragraph.
yes, your lordship. Sri Santanu Behuria recused from the deliberations due to conflict of interest as the honorable IAM is engaged with one of the bidders of the instant tender. Now, my lord would come to the second line of the para 2, my lord. However, due to paucity of time to represent, the complainant requested respective IAMs to allow them some time extension so that they can prepare for the said hearing meeting. After due deliberations. So this deliberation started by the IAM on, my lord, 6/2/2023 with intimation on 3/2/23. They say, consider their request for extension and reschedule the meeting to 9/2/2023. And my lord, such vital factor, my lord, and a person who knows everything, when he appeared, for timing 9-2, when he came to know that Sutanu Baharia is an interested person, he might have recused. My lord, on 10th, when they were given, they had not made any mention on 9th, fine, my lord. They did not know. But on 10th, when they, my lord, submitted the written arguments in terms of the IEM's direction, we both, oil and they both submitted written arguments. In that written arguments, there is not even a whisper. And interestingly, my lord, that written argument is not made part of the writ petition. I have brought it on record, my lord, in this compilation. And therein, my lord will not even find a whisper, my lord. And if the person had already recused or died, let's say on 9th he knew, what was the point in sending him that letter? This is all, my lord, made with an intention. They knew they are not qualified for the work. So that they can stall the work, my lord. This is the intention behind this one. My lord, my conclusion would be, my lord, it's not the question whether the company satisfied the criteria of the contract. The question is the company as it stands and, my lord, guided by its objects, MOA, in the MOA, well, it's not qualified to undertake this work, my lord. It's not even qualified to participate. Anything done beyond the, my lord, objects is ultra vires 1963, my lord. So, my lord, the company, my lord, knew about it when we wrote to them on 3/11. My lord, 7/11, when they gave us this, they annexed along with that the association, the amendment. Now, if the MOU satisfies the conditions, what was the need of the MOU, of the amendment? What was the need of the amendment? So you knew. So you showed it that it's on 1/8, but you refrained or kept it back. There is no explanation why they kept it back till 4/11 to forward it to the Register of Companies. And accordingly, within 30 days, 18/11, the Register of Companies did it. And, my lord, the law is that it's only on the registration and certification by the Register of Societies it will come into effect. Subsection 10 of section 13. And 9 says within 30 days, he will have to do it. So 1/8, 4/11. 4/11.
You want to say the fulfillment of condition, tender condition is one part, and meeting the statutory requirement is also
one thing, my lord. And here we have gone, we have categorically said that we have gone by the statutory requirement. And, my lord, they say complain and all. Fine, my lord. It was brought to our notice. Lordship would find one document here. My lord, page 149.
149.
149, my lord. Now, when they submitted to, my lord, the representations, my lord, we gave a reply, my lord. Because this copy was marked to us also, 148, my lord. The letter starts at 147/5/1/2023. Copy was marked to us. So we, my lord, gave a reply. And my lord would find what we have said there. A.
Where?
My lord, page 149. Reference your representation submitted to panel of independent external monitors of oil, wide the above referred letter against the subject tender. We would like to clarify a position as under. On scrutiny of your bid against the subject tender, it was observed that you submitted MOA that neither the core business activities nor the ancillary business activities incidental to the core business activities stipulated in the objectives of your MOA includes any business activity which have any relation directly or indirectly to oil and gas sector providing so and so, so and so. As such, you are found to be legally not authorized to provide the tendered service as per provisions of the Companies Act 2013, which states that a company is authorized to do only that much which is within the scope of the powers provided to it by its memoranda. Company can also do anything which is incidental to the main objects provided by the memorandum. Anything that is beyond the objects authorized by the memorandum is ultra vires. Then, my lord, we refer to our email, para B, we refer to our email dated 3/11/22. And, my lord, page 150. Accordingly, you forwarded a copy of the MOA wide mail dated 7/11, amended wide resolution, special resolution passed on the shareholders of the company in the extraordinary meeting held on so and so, adding the following objective to the company. to provide all types of services to oil and gas sector. Now it comes in, my lord. That's not there. However, my next paragraph. However, no document was submitted by you towards registration of the amendment with the ROC. You were therefore again advised by oil while email dated 22/11/22 to submit the certificate of amendment so and so issued by ROC, which was subsequently submitted by you by email dated 24/11. However, it was observed that the IOC had registered and certified the alteration only on 18/11/22, that is after the bid closing date. Then, my lord, we said that you are not legally competent to enter into the business of drilling services, and quoting the thing that's the reason why we clarified it. And my lord, a copy of this was also sent to the IEM that my lord would find
Copy of which?
that this same
Your reply.
the replies, my lord.
Okay.
My lord, it's a media, and my lord, my last submission, my lord, if even if lordship holds that TRIPAC or my lord principles of natural justice, anything, that the bias would have been there. My lord will have to also look into the decision making. Whether that decision that has been arrived at could be a different decision in view of the special, my lord, in view of the law holding the field, my lord. Even if, my lord, if the decision of oil, which has been approved by the IEM, could have been different, because the point is that only, it's on law. If that would have been different, my lord, it would be a different issue altogether, my lord. That's my humble submission, my lord.
You want to say that it's an objective testing, not subjective.
No, my lord.
There
It's
could
an
not- could
objective
not-
one based
could
on
not have
the
been, good two decisions.
lordship.
There could not have been two decisions.
No, there could not have been a different view, my lord, on that. Even if, my lord, the bias part is also brought in, my lord, but I'm not, my lord, saying that it is there, but my lord, assuming that decision would not have changed, my lord, because the decision is based on the Companies Act and the decisions of the government, of the Supreme Court, which, my lord, it was placed before the IEM and they have noted that. This is my humble submission.
We perhaps would not be able to have any other thing. Right from it.
A small issue.
We have understood your matter.
Yes,
That's it.
just one document that they have given to your lordships as a additional document that they filed at page 12. They have that appointment of.
The bunch, the bunch.
Yes, the bunch that they, at page 12,
Yes.
document 2.
Hmm.
There they have taken an effort to remove, I think it's because he was retiring, Mr. Gangadhar was retiring.
Hmm.
They had replaced him with somebody.
No, not
Their
here.
tenure to expire, so they had requested. There was no such required request made in behalf of him. That's all I wanted to point to you.
No.
We got Mr. Biboria. There was no request made. There was only a request of Mr. Gangadhar that was made. There was no request made on behalf of that.
My lord will see the date of that letter.
No, I agree. I'm only saying that that effort was made because he
Because
was.
we
because his
require
term was
IEM.
expiring.
IEM is required, my lord. This is a letter of 3/6/22, my lord. The
Yes.
date when the,
It will-
we do not know that who will be participating.
দুইটা হেৰি কৰিব।
ট্ৰাইফাকটো আমি ললো, এইটো আমাৰ ফিজ লাগিব। ট্ৰাইফাকটো। ঠিকনাটা বনাব।
Anybody appeared for Q4? No. Don't say anything. You haven't even stood up.
Participated in.
Hmm? So this Mr. Bihuria is a part of your directorate. How it's free RB Fukan, counsel for the petitioners in both these cases. Whereas the oil is represented, OIL is represented by UK Nair, assisted by Sri A. Sharma. Private respondent,
Mr.
number 11, is represented by Sri B. Chaudhary.
11 in the second.
Huh?
1061.
11 in WPC 1061. Represented by Sri B. Chaudhary. Hearing is concluded. Judgment is reserved.
Much obliged.
Right.
Item 20, well, the interim is still today. That was the case.
20 which matter?
Item 20 is a tender matter, my lord, where we have gone for retender, cancelling the earlier process. But
Regarding what?
for supply of liquid nitrogen to the ALDA, my lord, Assam Livestock
Oh, veterinary.
Veterinary, my lord. But lordship takes up the matter for a moment, my lord. My lord, in the order dated 1/1/2023, my lord. But the last order says, the last line says, however, after hearing the parties, the earlier interim order passed earlier stands modified to the extent that the authorities would be at liberty to go ahead with the tender process. However, the same should not be opened or finalized till the next day. But that open, possibly lordships indicated that let us go with the tender process, not to finalize. No, we are not finalizing, but the word not to open is also there. That is why they are finding it difficult.
We will have this for, I think this wanted to idle disposal.
Early disposal is.
Day after tomorrow?
urgency is there. Day after tomorrow.
Day after tomorrow.
Lordship.
We'll have this, you can, like to this matter, you can,
Lordship.
is there any motion, just immediately after the motion?
Lordship, will.
First
Lordship.
item.
My lord, item number 5 may come up on 18th, my lord.
They still give, any matter where interim order is still there?
14 and 15.
Yeah,
14 and
we here will extend this.
14,
Uh,
urgency is settlement process is under stay, my lord.
Hold
And this.
What was your item, Mr. Nath, Mr. Chaudhary?
Item 20.
2020.
20.
As urgency has been expressed, list for admission hearing on,
It has come for stay vacating, stay
list again, list on,
day after tomorrow.
date 3rd,
13th.
30th.
Okay.
30th of March. Liberty is granted
30.
to
This particular.
make a mention for upgrading the matter.
Item 14 and 15, my lord.
Lord,
Interim is there till today, my lord.
Interim has to be.
Interim order passed earlier to continue to next. Or Baki 14-15 or interim diva, next date, possibility of time. 14-15.
Early date, my lord.
Where 14-15?
15, my lord.
14.
Tell us,
Any date so convenient. Next week, my lord.
next week, tell us,
Tuesday, my lord.
next Tuesday.
13 may be interesting.
So he'll give this. Interim order, any matter where interim order is still till date? No. It will. फाइल बोलने की फाइल तो बोलने की ठीक है